And IA, from our side, I had to do a lot of personal scanning of the documents. It had to go through the Government of India scrutiny of the document and given to us by the interveners and it's taken a little time for doing all that. But nevertheless, they've been placed on record. There's an IA taking lordships to condone the delay in filing this document.
That's fine. The only thing attorney will be, please keep in mind the curative petition.
At some point, your lordship will hear us because we are objecting to these documents and we're coming on that.
No, these are fresh documents because of
Yes, they are documents which are not part of the record of the court. They are documents which are not part of the curative petitions. Wholesale new documents have been filed which we have never seen before.
There are two sets of documents. One, soon after the filing.
There is a Freudian slip. It says compilation filed by interveners.
Yes.
Nobody.
There are documents that are come.
Kindly wait. Please wait. We don't think any fresh documents can be permitted in a curative petition. If there is some data which is emerged or something which is emerged, we may or may not be inclined to do it. But it can't be a rehearing of the.
No, not like that. Not like that. The classification of document, like whatever was within the custody of the Union of India, Welfare Commissioner. So they're all part of the record over a period of time. But in order to collect supporting documents like how did they adjudicate?
No, attorney, let us understand. The settlement has arrived at a particular stage of time. Can we say that 10 years hence or 20 years hence or 30 years hence open the settlement?
I would be in a position
on the basis of some fresh documents.
No
certainty to law.
Not like that. It's not. It won't be like that. Yeah. Because if the settlement, there are two judges. Let's put it like this. Broadly, a settlement judgment and a review judgment.
Yes.
So in both these set of judgments, the court has expressed concern that it will be always possible for the court to have a second look at the matter because emerging facts will throw light on whether the court need to reopen this matter. And those facts have certainly emerged. And then, therefore, that's a primary consideration. So I'll be able to take your lordships through those documents.
What is the height of how? Did the government file a review at any stage of time?
No, I'll be able to answer all that. Whether the government filed a review or not would be a secondary question. We are looking at a very exceptional case.
So this is a matter of fact whether it's review is filed or not.
I understand.
There is no perspective to it.
I wait to explain all those things.
So as I understand, I'm just confirming the fact. As I understand, no review filed, curative filed after 19 years. Is these two facts correct or not?
Yes, there is no disagreement because we can't walk away from the fact. But I'm going to probably pursue lordships. These facts notwithstanding, in an exceptional matter like this, look at the entire literature and masters across the world. Everybody talks about the Bhopal gas matter.
Yes, maybe.
And therefore,
have you disbursed all the amount which has been deposited?
Yes, I'll give a complete detail on all that. What happened, what expenditure happened. I'll give a complete detail.
The money which has been deposited over these as a part of the settlement, does it fully stand disbursed or not? Fact.
All that is available, we have placed it on record. We fully disbursed. Beyond that disbursement, the Government of India had taken a stand to make an additional escalatia fee for all that has happened. I place on record details of expenditure.
Also, is the funds all utilized now? Or?
Yes. That is a complete set of information available. But what we learned from the objection is the interveners who were the original petition, many of them, have placed on record certain documents. I want to personally find out whether they can be taken on record as our document. Some of them I have some question, but nevertheless, in order to place the complete picture before the
please,
court, they will place.
Please address us how we can take these documents on record.
At some point, Bernard, I just wanted to say one thing. Because not just admitting these documents, the Lordship will have to first decide the construct in which this matter is to be done. For me, this is not an extraordinary case. There was a suit filed by the Union of India. In the suit, an interim order was. That interim order came in appeal to your Lordship's court, in which the Union of India and my client, UCC, settled. There is a settlement decree. The suit was disposed of. The review petition doesn't say set aside the settlement, because if the settlement is set aside, I am not willing to pay even a farthing. I can't be directed by a court in a 5-judge bench hearing a curative to say pay more. My liability has never been established. There is a consent decree. If there is no consent decree, if the decree is set aside, first of all, your Lordship will have to be shown on what legal principle the decree is set aside. And if that decree is set aside, the suit restores. And if the suit restores, consequences will follow and the suit will go on. This is not a case where my client agreed that as and when more data comes, please feel free to add to my liability. On the contrary, in the review petition, one of the grounds taken was that this settlement is bad because there is no reopener clause. Your Lordship said, yes, there is no reopener clause, but that doesn't mean that the settlement is bad.
So sorry.
1 minute.
Sorry.
The point, therefore, is please see the settlement. If there is no reopener clause, then the Union of India must say, we don't want set aside this decree. Then we will see where we are. And if that can't be done, all these documents to show that the Union of India should never have settled for so much is not something which your Lordships at this stage should be troubled with unless, I don't know what case do I have to answer. Do I have to stand here and say there is a mass tort case? Your Lordships are exercising your Lordship's original jurisdiction. It's an extraordinary original jurisdiction in which your Lordship will first try my client and hold my client is liable and then pass a decree and then take all this evidence on record without any testing or cross-examination and pass a decree on my client. So, it can't be like a public forum debate saying here is all this data placed by all these NGOs and now I can show you so many more people died. There were so many more injuries. Government of India got it horribly wrong in estimating the figures. Government should never have settled. So please pass a judgment against UCC, doubling, trebling, 100 times more of the original settlement. My client is not willing to pay even a farthing. We are saying this is what he settled. If you don't want the settlement, set aside the settlement. Let the law take its course. That is going to be our submission. So, and that is direct bearing on what documents you should look at.
I'll try to address all these questions. I don't know whether your willingness to pay or not is not the final word on the subject.
No,
if
what
you
he
walk away
says,
with a corporate,
Attorney, what he says is that if in a settlement he is paid X amount, correct? Can you say, normally these are extraordinary circumstances, but normally if somebody would try to walk out of a settlement, you say the benefit of the settlement must come back.
Yes.
there is
Then
nothing.
then you talk about it. So therefore,
I would probably go along the direction that we are not asking for a settlement to be annulled at no point of time, even though arguments were advanced during the review and earlier and some later applications filed. Please have a close look at the settlement. Did it bring about a just conclusion to the whole issue?
settlement
In that
is by
context,
two parties.
my submission.
Attorney, the settlement is by two parties.
Yeah.
In that sense, the court doesn't step into it and say, why did you settle? And one of the parties, Union of India, it's not a weak party that somebody can say, oh, there is an oppression and there's a weak party who is settled.
I quite take that, but
Therefore,
look
what
at
has been troubling and we've been trying to discuss with this, what is
I-
the scope of this kind of a curative petition? And after this period of time, in view of conduct, maybe you are right that this was, in your perception now, not the best of the settlements. You should have got more for this settlement. People should have got more for it. Can we reopen it?
No, I would be probably endeavoring to do that in the sense that we're not asking for annulling the settlement. But there are always situations when courts have amended a settlement, added to a settlement, if the justice of the cause demands that. I'm going to proceed on those lines. We're not asking for a settlement being annulled. And if I'm able to persuade your lordships on those lines.
It's not an issue of division of property that somebody will get a little more or less. That's not. It's a claim, tortious claim.
Yeah, that's
In a
true.
tortious claim, both parties settle. Having settled, is it open for one of the parties, that also Union of India, to say, look, I did settle, but I think I should have settled for more, or more should have been forthcoming. On that, whether other NGOs can write piggyback on that concept of a curative petition.
But
I'm able to link all those dots. That's what
I'm
I'm
sorry,
to
I
do.
only brought up.
I'm only trying to
I understand. I know.
put a perspective in place as to, for us also to appreciate what is the contours of submissions.
Very true. There are some unexplored dimensions of law in this case. Probably, if the lordships go along with this proposition, we'll be probably looking at a way of looking at it entirely different from how it's been looked at earlier.
But Malad, I assume the attorney would then give us something in writing of these unexplored dimensions, because his curative petition doesn't tell us what dimension.
It indicates.
I take it he's not going to then go beyond anything said in his curative.
How can they go beyond curative?
But Malad, I'm sorry, everything which has been filed before your lordship is unrelated to the curative.
But then have we permitted all that? No,
No,
we
I'm-
flagged it in the beginning.
I'm so sorry, I raised this point at this point.
Yeah.
Like, till we know what is the
No.
construct of this
See,
case.
when he, honestly, when I have no problem with it, he had arranged a compilation of record in such a manner that it would facilitate in our hearing the curative.
Malad, I'm sorry, your lordship's order was.
Absolutely.
Your lordship's order was, NGO documents are not to be taken on record. Union and Union Carbide, Union of India and Union Carbide, the two contesting parties, will give a joint compilation.
Joint compilation is always of what is on record.
Exactly.
In a curative
Yeah,
level, you
We
can't.
tried, we tried sitting with them, but we were not entertained. Their application.
No, don't say that. I had your instructing counsel sitting with me. I cleared those documents. I looked into them.
They then had meetings, obviously, I'm reading from their application for condemnation. They had meetings with the interveners. And a number of interveners' documents, which are part of the interim applications of the interveners, which are not on record, are now put before you. And they have.
So the first question is, are we or can we look into what is not part of the record already? I'm absolutely clear what our intent was when we said compilation. Our intent was record becomes very, very in these things becomes very haphazard. Haphazard.
Waste of time.
Number two, and also more so because it's a curative, very limited scope. We are not required to look into 11 volumes. Therefore, take out of the 11 volumes what you feel is relevant for curative. That is it.
I have done an analysis of the indices of these volumes.
Let me have the benefit of the
Of course.
And if and may put it like this.
Your lordship just.
क्या करते हैं हम
For you.
page 120 of the main compilation, paragraph 198 of the review judgment. 198 of the review judgment.
This is curative petition.
Main compilation of the curative petition, volume 1.
Yes.
Because the review judgment holds that if there is shortfall, It is the duty of Union of India to pay the compensation. That's the question we want to ask you. Just see page 198. Paragraph 198 on page 120. That's the review judgment.
Kindly just read it aloud so that
Our submission. There is a settlement.
Just a minute, but he's not getting it. Please see volume 1. Volume 1. Volume 1, page 120.
1991
3rd October 91 judgment
it's a para 198 of the second judgment which you left.
and SCC reference page 682.
I just come. Paragraph beginning.
After a
after
careful
careful
thought.
thought.
Yes.
Yeah.
It appears to us that while it may not be wise or proper to deprive the victims of the benefit of settlement, it is however necessary to ensure that the perhaps unlikely event of the settlement fund being found inadequate to be the compensation determined in respect of all the present claimants. Those persons who have their claims determined after the fund is exhausted or not left to fend for themselves. But such a contingency may not arise having regard to the size of the settlement fund. That is, however, a hypothetical situation. If it should arise, the reasonable way to protect the interests of the victims is to hold the Union of India, the welfare state, and the circumstance in which the settlement was made should not be found wanting in making good the deficiency, if any, be hold and declare accordingly.
So
We
what
have
is
some
what?
question
So
about that.
there are two aspects of it. One aspect is that therefore I asked the first question, which arose from the statement if the fund is exhausted. Now, it does appear from the last time, my recollection is of the last state's hearing, where it was pointed out by the council that there are still funds lying deposited by Union Carbide which are undisbursed. They say 50 crore, you will be able to answer what is the amount. Therefore, when the funds are lying with you, it's not a question where funds are exhausted. One. Even 25 years down the line.
There are some parallel writ petition
I'll
filed.
put it slightly different. If you got to
Let me put it, then you answer it your way.
Yeah.
This is one aspect.
I try to look at
Yeah.
both, varied points of it. I mean, it's not as if.
This is one. Secondly, what my brother rightly points out is that were the funds to fall short also, you are the one in Union of India, you have to make it up.
There are in the curative petition and in the documents which are filed in support thereof, the argument is that there are 3 claims by Union of India, which is set out in the curative petition. So under each of the heading, we find that the amount which has been made over to us under the settlement fund is inadequate. Number 1. Number 2, the figures on the number of deaths and the categories of injuries, permanent, temporary, etc. The figures have gone much beyond what the review court found at that point of time. That's why they say present claimants. If the figure of deaths was 3,000,
How come amounts are still lying
and it's
undisbursed?
more than 5,000.
How are 50 crores, if at all, lying undisbursed, which means people are not getting the money?
No.
Are you responsible for the money not going to the people?
I see that. That's why I try to look at the angle. What was the total corpus of money available from the settlement fund and how it has been expended? That's one aspect of the matter. But at the point of time when the review judgment came to a conclusion that the present claimants and the fund is adequate to meet the claim demands of the present claimant, we were really able to show that it is not so. The number of claimants as determined by the welfare commissioner has gone beyond what the review judgment had in mind. Therefore, that's a basis for your lordship being asked in the curative petition to go beyond the review judgment.
I think
to
the
find out
correct thing would be, let us see your curative petition first. What
But
was the
I
curative
just wanted to make one little.
Because these are all figures.
There's a starting point.
Please address us why and how, according to you, not having filed a review of curative is.
And my lord, please,
I have one more submission to
your
make,
lordship
which I-
should not take these on record, their compilation.
We have not as yet taken into.
No, I would probably suggest whatever objection.
We have neither said
we get
yes
to
nor
look
said
at it.
no at the moment.
Because these are just exchanges. I try to look and find out. I'm told many of the documents which objections are being raised have been played by the interveners earlier than pointed out, soon after the curative petition was
See, we
filed.
can't.
They were petitioners and they intervened in the curative petition.
May have.
Therefore, if
Today question is your curative petition.
it's my
We
curative
can't
petition,
let, and your curative petition is not, is it or is it not?
I
It's
would
not preceded by
probably-
a review. There are many, attorney, all we are pointing out is, there are many hurdles in your way. You may be able to cross it, yet we don't have any.
so there are, see,
Just to finish this point.
in both the settlement judgment and in the review judgment, and in some of the interlocutory applications filed over a period of time. And just look at these cases when the act was put a challenge. A post-decisional opportunity to the claimants, I think, is desirable, has been emphasized in more than one place. Therefore, if the act has to some extent considerably removed the claimant's voice being heard in the most requisite way, and if that's how it should be done, and if the review judgment, according to my reading of the review judgment, it has left open a considerable avenue and a window for a court to relook at the settlement corpus. And if that is open, I think documents will throw considerable light on the various facets of the case will have to probably receive unless in serious objection to the sources from which you got those documents.
Not so
The
safe.
process which you obtained.
You have to link first. You have to subject to whichever way you want to go about. First, you have to say, at least in my thinking process, how a curative petition without ever having filed a review petition would lie. One. Number two, what is the scope of this curative petition? Then we'll come to whether any further document can be taken.
To put it shortly, if I'm probably able to take it out on these lines, if the Huda judgment had in mind a certain set of circumstances post antulate, the writ petition being filed to reopen settled judgments of court, either in the specially petition, the appellate jurisdiction, or even into jurisdiction, Naresh Vidas onwards. So if the court had that in mind, principles of natural justice. So I'm probably able to tell you, Lordship, the principles of natural means a fair hearing. A fair hearing means, like what Justice Ahmed said in the Allahabad High Court, that if a record of a case were not before the court, there is no fair hearing.
So, according to you, government did not get a fair hearing, or the government did not know how to give a fair hearing to others?
I've only brought the
Curative is a very, yes, this is a door or a window which has been
No,
opened.
maybe.
But it is every year closed for 200 cases, hardly anything comes out of it. Because there must be some very rare and compelling circumstances.
I'm in complete agreement with
under
that.
which
But
it has to be
in a case of this nature, which defies several logics of the due process of law, and where therefore the court will admit certain routes, certain processes.
But you are
part of the
arguing on a
Buddha
basis. You are arguing on a basis you don't want to open the settlement. Because you are in a you have many slippery areas. If you say that they open the settlement, that will create its own complications.
I've also looked at those other instances, for instance, US litigation, the aspects of litigation, etc., where the courts have always left like the reopening clause. I mean, in some settlement, there is the reopening clause. That does not mean if the reopening clause is not there, the ends of justice will close that.
No, here the clause is, well, if a situation arises to increase the claim, you do it. That's what
I take a lot to some of the observations in the review judgment and say that yes, there was a concern, an underlying concern.
On the settlement, para 199
119.
and 200 of the same judgment.
No, I would probably, these are just broad reflections.
Kindly just read 199 also in the sequence.
Probably, I'll read that.
Next paragraph.
I'll read that. It is relevant here. The Union of India quite fairly, for this fact settlement power sought to assail its validity on certain legal issues. But the fact of the settlement was not disputed. Indeed, Union of India did not initiate any substantive proceedings of its own to assail the agreement of the consensual relevance constituting the substratum of the order of the court. The legal contention as to the validity of the settlement is permitted to be raised in as much as that an order made on consent would be at no higher footing and could be assailed on the grounds that an agreement could be. And, but that as stated earlier, the factum of the consensual nature of the transaction and the existence of the fact was not disputed. Those legal contentions as to the validity have now failed. The result is that the agreement subsists. I've seen that. But I would probably be able to urge your lordship that if in other parts of the judgment, the court has expressed its concern. If there was a need to look at on the basis of emergent facts, which emergent facts are beyond dispute, if you put it like that, then this will not come in my way, neither in the way of the Union of India, nor in the way of the petitioner who have legitimate claims to demand the settlement to be amended. We're not asking the settlement. The court will find, yes, the number of figures that you shifted to amend the settlement. It doesn't depend your volition. It doesn't depend on anything you want to do. Look at the way the whole transaction happened in 1991 as the review judgment. Your corporate games people always play, restructuring the internal structures. So today, the United Nations laid down certain guidelines on how human rights concerned. It is certainly a factor to be taken into account. We're looking at global commerce and global trade, multinational enterprises. The emerging trend of views looking about how to look at that. Therefore, it's not as if you're looking at an isolated tort case where somebody will have a private liability issue to be determined and walk out of that. For certain diamonds, what I to present your lordships.
Okay.
I'm anxious. Thought has gone into
Let
it.
him,
I know there are some difficulties in it.
let
But
him
if you are
proceed
able
with it,
to-
otherwise we'll
I just want you to get one thing clear. Would your lordships, because where we are today, would your lordship see your lordship's orders of February and April 2011?
Yes.
Some confusion was created. We want to be very clear.
Which order are you speaking to the?
If your lordship is pleased to turn to the first order of February 2011.
February 2000?
11. It's 28th February 2011.
Yes.
It says, generally in curative petitions, hearing in court is not guaranteed. However, looking for the larger public interest in India, the petition involving substantial question of law, we have decided to hear these curatives in court. 345 transfer petition, issue notice, custody in addition, etc., etc. Then, and there were two curatives. One was the criminal curative. One was the civil criminal that has been dismissed. Then on 13th April 2011, it's another order where the pull and push of the hearing before the court started hearing the criminal matter. At page 3 of the order, there was a notation saying interlocutory applications 7 and 9 are allowed subject to service.
Yes.
Now, we mentioned the matter and saying this wasn't accurate. And so on 13th April 2011, your lordships added the sentence. In the 13th April 2011.
Yes.
If your lordship sees, this is the revised order, interlocutory applications are allowed, issue notice on the maintenance of interlocutory applications and the merits of the matter. So first of all, maintainability of the merits of the matter needs to be gone into. Then the maintainability of the interlocutory. And that's where we are. And on that basis, my lords made note on the last occasion where your lordship said there is no liberty to find anything beyond the record of the curative beside the primary issue.
Yes.
And our position is very simply as follows. There is a settlement. Now, there is no reopener clause in a settlement. Of course, the attorney is going to show your lordship jurisprudence saying 30 years down the road, because of corporate games being played, the court can rewrite the settlement and get my consent. And my consent is unnecessary, it will still be a settlement. However, whatever else there may be, one important jurisdictional factor your lordship would know. And I just want to place it because we put this on as not only was curative jurisdiction unknown when all this started, that nothing much may turn on. The Union of India filed a suit in New York. Union Carbide applied for transferring the suit to India on the principle of foreign non-convenience. The question was, would Union Carbide, an American company, which had no presence in the Union, abide by the jurisdiction of an Indian court? in Judge Keenan's order, our undertaking with the record is that we will abide by orders in the suit. And that is how the suit started. The suit was at an interlocutory stage where an interim order was made, the matter came here and the case got settled. Today, I am not facing any judicial review proceedings or an Article 32 proceeding by somebody saying, you're a multinational, you're a bad boy, you should be asked to pay more, because then the question would arise, if notice is issued, will Union Carbide accept service? It's an American company, it may accept your lordship's jurisdiction, it may not accept your lordship. So it can't be in a framework of this kind, where it arises out of a suit. We bring in some principles of constitutional law, etc. Our position is, and I'm just stating it, and then of course the attorney will assist you. Our position is as follows. There is a settlement between the parties. Now, one party is telling the lordships, I was hopelessly ill-informed in arriving at the settlement. That's at the highest court case. And there were elements in the settlement. Relief and rehabilitation was expressly excluded from the settlement. They are now asking for relief and rehabilitation, and it should have been part of this. We are saying we have not agreeing to revising any settlement. I'm not saying whether my permission is required or not. I'm saying I'm not agreeing. Now the question is, what in this curative petition would your lordships be doing? The point is your lordship will have to budget it first. Are your lordships exercising some extraordinary jurisdiction in which your lordship will say the settlement shall not read this way, but the settlement will read differently, and you are deemed to have consented? Or your lordship will say, we don't need your consent. We are now passing a decree in the suit without there being a trial, some principle. And I don't know what principle that, because in the curative petition, it only states, this is the settlement, these are the figures, this is the amount, therefore. What legal principle it sits on is not clear. We ran this point in the counter in pages and pages and pages of the counter. And a rejoinder is filed by the Union of Human. And I just want to show that, and I'm done, then we're not the attorney. Because I am saying, I don't know. What is the case I'm facing? When I ran this point in the counter, and I won't waste your lordship's time reading it, your lordship will take it in pith and substance. This is the defense we raise, saying this is the consensual arrangement. You can't unilaterally say. There is a rejoinder filed by the Union of India. I don't know where it is. Where it is.
What does it say, Mr. Salve?
Yes, I'll read out 2 or 3 paragraphs. It says, the petitioner has not given any appropriate reply except taking technical objection. Technicality should not defeat the dispensation of justice. Settlement was done in special circumstances of excellence and nicety. The legal principles were overshadowed. Explained by the lordships in so and so. In the same judgment, their lordships made so and so observation. It is submitted, claims fall in 3 heads. Justification has been explained. Settlement proceeded on certain assumptions. Those assumptions turned out to be incorrect. And the debts which are finally adjudicated turned out to be so and so. The justness of the settlement was based on the assumption of truth by this court. It is submitted, basic assumption being incorrect. The settled amount requires to be suitably enhanced. So it doesn't tell me on what legal principle the government of India is saying that this settlement amount has to be enhanced. When in my counter I say a court cannot. This is a settlement of a suit. There's a suit on the original side and the court of civil procedure.
So the attorney will explain how.
I'm only saying today, I don't know what case I have to answer.
In a suit,
if he has something in writing, I need to take instructions.
Let us see. Let him begin.
Yes.
When
I only want you to
suit to be in a suit to be tried, where it is settled beforehand on certain terms.
Yes.
On what principles that settlement can be opened, keeping in mind the 2 judgments. We'll have to keep in.
I'm sorry, but I go one step further. Let me assume my learned friend can persuade your lordship that the settlement is wrongly entered. Let me assume. Then the settlement has to go.
We've taken note of that fact.
And have they made
But that's not his argument. See, therefore I put
that's my problem.
His argument is, I'm
Court can retract the
I'm
settlement.
not asking for reopening of the settlement, but I will show jurisprudence to say that even where such a claim is settled without opening the settlement, the opposite party can be burdened with some additional amount.
And that jurisprudence, I have, I'm purely on the procedure of today. I don't know what that jurisprudence is. I wish it was in a note, a submission, a right.
You will have the, as we will have, you will have the benefit of hearing the attorney how we bring the
Very
word.
That's fine.
I would have definitely done that, but what took me a little time was to scan the mass of documents to find out how do we really navigate in a case like this. And, in order to pursue a lawsuit, to simply say, look, at the curative petition has placed certain facts. Let me confine myself at a threshold to those facts. If those facts were good enough to pursue this court, we should notice the curative petition for a further consideration. And on a further consideration, those facts, if this court were to reach an immediate conclusion, yes, we will get into the merits of the matter as far as the finality of the settlement is concerned. And if those facts are good enough and persuasive enough to have, or to repeat what I said, to have the settlement amended as far as the quantum is concerned. Because the question of settlement, its need, relevance, and expedition, etc., have been gone through both the judgments, having regard to the enormity of the tragedy in this case. And therefore, notwithstanding that, when claimants had a reason to tell the court repeatedly that this case does not admit of those usual principles of a civil procedure code or even settled principles of tort, look into the court, you need to draw a different kind of a map altogether. Repeated attempts are being made. So in that context, if the minimal facts which have been placed in the curative petition were good enough to request the court to go further into the matter, then I would have done my job. So if there are objections to the document placed on record, I'll certainly look into some of them. But I want to say that the interveners, you have kindly come to the order, last order only, the document compilation, the 11th of October 2022.
Yes.
Both the interveners are originally petitioners in many of these proceedings.
Maybe.
And they've been pleaded as petitioners. I read Your Lordship's directions are in the conspectus of the aforesaid. We issue the following directions. The government would represent the claim of the person who suffered, and thus a joint compilation be required to be prepared with the office of the Attorney General and the respondent, which would be a compilation alone to be referred to in the proceedings. Insofar as the applications associations are concerned, we do not give any liberty to file any pleadings, but at the relevant stage, we will see to what extent assistance will be given by the council. We do not foreclose their rights to be heard by us at our discretion. Then, in conclusion, at the request of the Attorney General, some documents are permitted to be placed on record, limited to updating the position at ground level. There are two classes of documents which I received. One is the document to the process of the Welfare Commissioner, which updates and, in fact, confirms what has been stated in the curative petition. In the second set of documents which throw light on what happened post 1991, the review judgment in relation to the position of UCC and what happened elsewhere in US and how certain transmutations have taken place. And also in regard to the documents which are placed by the interveners and the petitioners along as soon as the curative petitions are filed. We are part of the record before lawsuits began to hear the matter. So I took
When
some
the
of the
interventions have not been
at
allowed,
no
when
point
the
of
petition
time.
of documents filed by them being part of
In
the
2011, they were placed on record. I did not find any so far any objection raised to the placing of the document. Probably occasion did not arise. Let me look at it very broadly. Let me, because we are in a case where many of these issues will be contentious. But regardless of the contention, for very good reason, let me say. If the court were to say, yes, let us look at the substance of the matter. If any of these documents will throw considerable light on which way the court will proceed to hear this matter, I would only urge your documents to let the document be placed on record, regardless of any objections. And objections can be, how did they get these documents? What kind of source?
No.
Are they legitimate? I can understand all that.
That's not
So I would urge your documents to probably not to say to the documents being looked at this point of time.
No, first you'll have to lay down.
You lost
What-
ultimately reject them.
No, it can't be reverse way. No, that's not something permissible. That We will first read them out and then you may reject them.
You know, it will be like a case like this, perhaps
No,
I would probably.
I'm sorry. I'm
Some of
sorry.
the documents were very important dimensions.
We will not permit you to go.
There are two classes.
We cannot permit you to go like this.
Let me try to.
You will have to first canvass your case as to what is broadly the case. Then we'll see what extent we are willing to examine it and whether we should at all permit some document to examine within the niceties of those pleas.
Let me put it like I quite see that. Because after all, the interest of the Union of India in a very extraordinary case like this, in a curative stage, is that I don't want to get locked into a debate where some documents, even remotely relevant, indirectly relevant, I get locked into that. I would like to probably urge the court to get along with this matter, maintainability curative petition, and what grounds with the curative petition is stated, and what official documents are available to show light to the case. And thereafter, if I'm able to still say at that point of time, if the documents can still be looked into, I don't want to get to that right away.
That's why, Attorney, we did not reject it at the threshold. What we are saying, you begin with your case minus these documents. We'll see how it goes.
Yeah, I quite see that. I think it's important to the purpose of both parties.
Can you just, we all know the parameters, Pura's case, the parameters of curative. Can you crystallize what are your arguments? What are the grounds on which you are raising this? Exactly what is the ground 1, 2, 3, 4?
Right.
And one, the documents which were already on record.
Right.
The documents which were not on record. There will be obviously data, etc. There may be huge dispute as to the figures itself. Because what has been collected, not collected, causation, cause of death, etc. is very complicated. It's not so simple. Even medical science causation is not so simple.
And we are not.
And if we open up that, it will be firstly a full-fledged trial.
We are not analyzing trying a suit.
I'm
not trying.
No,
I'm saying we are not trying an original suit, which must be understood.
No,
in a suit filed before the trial court, a settlement has arrived at here. Therefore, we are saying how, in what manner do you seek to open that settlement, and whether by saying that we are not opening the settlement but adding to the settlement, can it take place? Because you're not opening the settlement. So can you add to the settlement one way or the other? Let's put the reverse way. Suppose some facts would have arisen, which would have shown that actually the scenario was less horrific than it was made out to be. Okay. Could the other side have come and said, look, this is an excess amount I've paid. I want some money back. Could we have permitted that?
I would.
See documents में जाएंगे.
See, शुरू तो करें. Setting out the contours of it.
Yeah. So the skeletal list of judges we thought good enough for the day to open up.
I'm sorry, but there are facts stated in this based on documents which are not admitted as yet.
Anyway, you will have your.
You will have your chance. We'll
There are only dates.
I don't.
that issue, Mr. Salve, we already flagged in the.
No, I'm sorry, Mark. There is a item saying meetings were held and correspondence between so and so scheme of the.
Anyway, when I
We are
trying
only
to read the document,
we are only looking to the facts. We are not
No,
looking
no,
to the
no,
documents.
those facts are based on documents which are now being introduced.
We'll deal with it. Let us begin. Otherwise, we'll not end.
and it's more. And I've also had a very brief note of my argument. This will be supplemented later by a detailed note. I have both of them ready with me.
Yes.
So let me take a lot of the list of dates to have a broad overview of the matter. 1963 to 1970, Union Carbide Corporation sanctioned Carnegie Mellon Institute to conduct a toxic study of metal isocyanate, the findings of which were highly toxic with purulent skin penetration. It presents a definite hazard to life by inhalation. In 16th of 1974, Union Carbide India conducted an internal study in the safety of MIC. In the study, it was found in Kerala the highest rating of hazard for the internal pigment system, and the stringent precautions were taken to avoid any sort of human contact. It recognized that the poison made the residues likely in spite of prompt treatment from explorers. The document is obtained through the discovery process in so-and-so, Saga was Union Carbide Corporation, and in the U.S. District Court of Southern District of India. Then 2/12/1984 to so-and-so. On the intervening night of 2nd, 3rd December, a lethal gas stove ran the Union Carbide leaked into the atmosphere, causing large number of deaths and serious injuries to a large number of people. At that time, Union Carbide Corporation owned 50.9% of the Union Carbide India Limited. 20th of February, Union of India enacted the Bhopal Gas Leak Disaster Act and changed the Bhopal Gas Disaster Registration and Processing Scheme for registration, processing, determination, and compensation to each claim the appeal revenue arising therefrom. The Act authorized the Government of India as parent patriot to represent the victims and pursue their compensation effectively and equitably. Then meeting were held and corresponding exchange between so-and-so, and persons from the Ministry of Chemicals and Fertilizers were in the scheme of the negotiated settlement to discuss based on the multi-tiered injuries. These documents marked top secret for review on filing RTIs. Then 8th of April, Union of India instituted action on behalf of the victims against UCC in United States District Court Southern District of New York for award of compensation for the damage caused by the disaster. Then 12th of May, 86, Keenan, United States District Court of Southern District of New York dismissed the consolidated action instituted by Union of India and individual claims on the ground of foreign non-convenience in favor of the Indian foreign. 86, Union of India filed original civil suit in the Court of District at Bhopal against UCC, seeking compensation on US $3 billion. 13th of November, the Court of District Judge Bhopal passed an order in the original civil suit directing UCC to make an unencumbered assets of a fair market value of $3 billion to meet the decree passed by the court. On 17th of December, the Court of District at Bhopal as an interim order directing UCC to deposit rupees 350 crores for payment of substantial interim compensation and welfare measures for gas victims. Then 4th of April 1987, the Madhya Pradesh High Court at Jabalpur passed an order in civil revision by filed by UCC against the order dated 17th of December, whereby the quantum of interim compensation paid by UCC reduced to
Just one second.
240 crores.
Some date may be wrong, I think. This first order of District Judge Bhopal is 17 December.
That's right.
Then you are saying
That's
Madhya
the interim
Pradesh High Court at Jabalpur passed an order in civil revision against order of 17 December On 4th April, it can't be.
Must be 88.
88, I believe. That is 88?
Is it 1988?
It's 1980. It's not, that's a moment. 80.
88, okay.
Then 88 special petitions are filed by both Union of India as well as UCC, so on. Then 14th of today, Supreme Court in civil appeal passed a settlement order directing UCC to pay a sum of rupees US for 70 million to Union of India as full settlement of the claimant rights and liability that has been of MIC gas is called a settlement order. Then UCC is also deposited sum on the Union of India. Then Reserve Bank of India issued a letter indicating the procedure for the operation to account where the US dollars were converted to Indian rupees only when the same was required for disbursement. But that the loss in account of an exchange rate difference was borne by the Union of India. Then 14th of May 1989, Supreme Court in Civil Appeal number 7, SLP number 7, passed an order enumerating the reason and the basis that persevered the court to pass a settlement order for US for 70 million. The court considered the following estimates while arriving at the settlement amount. Let us look at the number of debt. Debt, the assumed case of 3,000, amount allocated 70 crores, range of compensation to be paid is 1 lakh to 3 lakhs. So permanent disability is 30,000, temporary disability 20,000, at most severe case of 2,000, minor injury is 5,000. So that's how the figures are reckoned for the purpose of distribution of this compensation. Then 22nd of October, Supreme Court with a judgment dated so-and-so, report on so-and-so, upheld the constitutional validity of the Bhopal gas leak disaster processing transaction 1985. 1990, Union of India approved a 5-year action plan of the state government of Madhya Pradesh with a capital outlay of rupees 163.10 crores for the medical, economic, social, and environmental rehabilitation for the Bhopal gas victims. The outlay was subsequently revised upwards to rupees 258 crores. The aforesaid action plan was to be shared by the government of India and the state government of Madhya Pradesh in the ratio of 75-25 and implemented by the state government of Madhya Pradesh from 1990 to August 1999. The 3rd of October 1991, Supreme Court dismissed the review petition filed against the orders dated 14th of February 89 and so on, and upheld the settlement orders. 13th of April 1992, the government of India laid on guidelines for determination of the compensation according to the directions of the Honorable Court with the order dated 14/5/1989. Then again, the government of India amended the guidelines for determination of the compensation and raised the compensation of death from 1.3 lakh to 1 to 5 lakh, 1 to 3 lakh to 1 to 5 lakh. The next, 29th of September, while not providing any documents on the safety toxicity of MIC to the government of India, UCC submitted the carnelian toxic study of MIC to the Environmental Protection Agency in the US for statutory purpose, claiming that the document was confidential and the UCC retained publication rights of the report. Then October 92, Office of Welfare Commissioner Bhopal established in the process of disbursement of the compensation initiated. 1994, UCC, after the review judgment, UCC sold the entire 50.9% Union Carbide India Limited, the McLeod Russell India Limited, Calcutta, a part of the Williamson merger and Maker and Company Limited Group. UCIL was renamed as Everyday Industries India Limited. The new company had 2 divisions, the bulk tea division and managed the tea estate, the McLeod Russell, and the battery division, which marketed the Everyday batteries and flashlights. As part of this transaction, EIIL became the lessor of the property and assumed full responsibility for the environmental cleanup of the site. In 1998, the government of Madhya Pradesh revoked EIL's lease of the property and took responsibility for the property on as-is basis. And 1st of April 1996, McLeod Russell India Limited merged with Everyday Industries India Limited with a Calcutta High Court order 16/6/1997 sanctioned the scheme of merger. Then 1998, Everyday Company India Private Limited incorporated. The 19th of July 2000, Everyday Company India Private Limited changed its name to Everyday Company India Limited. Then 2000, I'll come back to these transactions a little later to show the corporate, gains. Then 2000, Bhopal Memorial Hospital Research Center was set up by Bhopal Memorial Hospital in accordance with the order of the Supreme Court to provide free treatment to the victims of Bhopal gas leak tragedy. Then 2001, Union Carbide Corporation became a wholly owned subsidiary of the Dow Chemical Company. 1907-2004, Supreme Court with the order date in IA number 46 and 47 of 2004 directed the Welfare Commission to disburse the balance amount of approximately rupees 1,500 crore that had accumulated to the Reserve Bank of India on account of accrual of interest and exchange rate variations on pro rata basis at the claimant those cases had been settled. Then 1/4/2004, Bharti Division was was demerged in favor of Everyday Company India Limited. Then 14 to 2005, Everyday Company India Limited changed its name to MacLeod Russell India Limited under a fresh certificate of incorporation. 4th of February, May 2007, Supreme Court dismissed IA number so and so in civil appeals number so that were filed to re-examine the inadequacy of Bhopal gas settlement. June 2008, 40 metric tons of line sludge was disposed of in the treatment, storage, and disposal facility at the Pithampur near Indore. Then 7/6/2010, the trial court at Bhopal, with a judgment and order, convicted the accused persons in section 304A Indian Penal Code and recorded categorical findings against the accused person. However, a mild sentence was imposed on the accused person. In 2010, Union of India took a comprehensive review of all the issues pertaining to the Bhopal gas leak tragedy. Accordingly, the central government, the state government of Madhya Pradesh, approved a sanction of rupees 72.75 crore to be shared in the ratio of 75-25 by implementing the new action plan 2010 for various rehabilitation measures to be taken for Bhopal gas victims. Central government allowed an amount of rupees 740.28 crores to be disbursed as a gratia of the Bhopal gas victims under the categories of death, permanent disability, injury of utmost severity, and temporary disability cases. Two additional categories of cancer and total renal failure cases were also added for ex gratia payment in view of the increasing number of such cases. Compensation was as follows: death 10 lakhs, permanent disability 5 lakhs, cancer cases 2 lakhs, total renal failure 2 lakhs, temporary disability 1 lakh, less already received. In 2010, Government of India took over the BMHRC hospital and the BMS test was dissolved after the directive of the Supreme Court. Then 11th of October 2010, Indian Council of Medical Research was established with the mandate of conducting research in the field of environment health, including the research on the health issues of Bhopal gas tragedy victims. In December, Union of India filed a pre-curative petition before the Supreme Court claiming enhanced compensation in the response. Supreme Court issued notice and directors seemed to be heard in the court. Then 11th of May 2011, Supreme Court dismissed the curative petition in criminal appeal number so and so, and that's a slightly different issue. Then 11th of December 2015, Dow and EI DuPont, the Nomos and Company, merged to form Dow DuPont with equal shareholding. Then 2019, Dow DuPont demerged into 3 separate entities called so and so, so and so. The spin-off was completed in April 1, 2019. At this time, Dow Incorporated became an independent, publicly traded company and the direct parent company, Dow Chemical Company. So these are broadly the set of facts which give an overview of the post-1994 two set of transactions. One, what happened to the compensation amount, how it was dispersed, and the need arose for the government of India to have a relook at the entire issue. And on the other hand, the transaction post-1991 between UCC and the series of internal corporate restructuring, including what happened in US. Both of them are connected in a manner of speaking. I'll be able to tell you a lot why, notwithstanding all these developments as regard to corporate restructure, if at the first point of time, if UCC had told before the US courts that on grounds of forum non-convenience, the Indian courts will have a say in the matter, and the Indian courts will cover the jurisdiction. And the settlement of the parts of the jurisdiction issue, you cannot, on any volitional act of yours, for any reason whatsoever, resile yourself or to be relieved from the jurisdiction as your liability. If a liability and jurisdiction coexist, then the court will be free to examine further. As suppose 1991, on the basis of the liberty given by this court in the review judgment to examine the case on a research conducted by ICMR and so on and so forth, and then the process adopted by the Welfare Commissioner, that is the increasing number of deaths, the increase in the number of other categories of claims, then where do we go further? That's a question to be answered. So let me take a lot of brief notes and try to flag how probably that is the way of looking at it.
According to you, in the October 91 judgment of the review, there is a liberty given to the union.
I'll be able to show those passages from
Which paragraphs?
I just let me take the lordship on what I thought would be one way of looking at the whole issue. I know there are certain gray areas where the court may be called upon to fill those gray areas and gaps because we have absolutely no precedent where a mass tort litigation. I also place on record some compilation, but the US Mass Tort Group has considered a whole lot of settlements in the US courts and aspects of cases. And where the settlement allowed a reopening clause, and where it did not. And look at those categories of cases. And concerns are being expressed by academic writers. And look at the absence of a broad framework of law, which may deal with some of those, gray areas. Liability, jurisdiction, conflict of laws questions, etc., can be addressed. So I'll take out all this very later point of time. So if this is a broad mode of arguments, would be good enough. And then I have to take the lordship in the review judgment and settlement judgment and see where probably how we can proceed. May I read this brief note? The curative petition is maintainable, both within the scope of the judgment titled so and so, and on necessary additions to be stated as to encompass cases of instant nature. It effectively addresses the lingering gap in doing complete justice to the Bhopal gas victim, which has remained despite several attempts. Seen in the light of concerns expressed regarding the need for doing complete justice while affirming the settlement, neither the settlement judgment nor the review judgment can be seen as the last say and shall not come in the way of the adjudication of the curative petition. The intervening events in development between the review judgment and the filing of the curative petition and subsequent thereto are relevant factors persuasive enough for the honorable court to engage in the adjudication of the curative process for doing complete justice. For the reasons set out both in the settlement judgment and the review judgment, and other facts and circumstances of this case, the continuing engagement of this court in monitoring the due enforcement of the settlement, the adequate availability of medical facilities, and the need for engagement in medical research, etc. Notice in 2012 AKCB 326, the review process will be seen not as having come to a termination, and the curative adjudication deserves to be treated as a continuation of the review process and not as a standalone procedure. This honorable court has always endorsed the importance of reviewing his own judgments in the public good. Post the judgment title so and so, in addition to the grounds of public good and justice, the curative doctrine has added an important chapter on post-review adjudication. On a reading of all the principles that can be gathered from the judgments of the honorable court, it can be stated that the curative petition will be considered as the most appropriate source of doing complete justice. UCC is in breach of its twin obligation, namely the obligation to observe its duty of care and the obligation to do rectificatory justice by payment of relevant compensation. As long as the relevant and adequate compensation is not finally determined and paid, the obligation to make good the compensation will be treated as an undischarged obligation. For the purpose of securing due discharge of the obligation, the principles of restitution, tracing, and disgorgement of benefit and any other equitable principle of justice can be suitably fashioned and applied having regard to the special and unique features of this case. By reason of application of the principle, the respondents howsoever connected, should be held liable. The conventional approach of looking at connected corporate entities as distinct legal entities, either for determination of liability or exclusion thereof, will be singularly unjust and in infringement of the gas affected persons' right to life under Article 21 of the Constitution and their right of access to justice. The Bhopal Gas Leak Disaster Act 1985 is reserved to be construed as a state intervention in the safeguarding of Article 21 rights of the victim must be read as expansively as possible to be in promotion of the rights of the gas affected people. The principle of power coupled with a duty will be read into this law, and the Union of India can both act suo motu as well as be compelled to act in the interest of justice. See so and so, so and so. Then none of the orders of judgment of the Honorable Court reported in 2007 9 SEC and 2011 so and so can operate either as res judicata or otherwise as a bar to the effective disposal of the curative proceedings. Sufficient facts and materials have been placed on record, which warrant reconsideration of the basis of the criteria adopted for payment of compensation to different categories of gas leak victims and also the quantum of compensation. On the application of well-set principles, namely mistake or fraud for reopening a settlement and for effecting amendments thereto, the settlement in question is liable to be reviewed. The effect and impact of gas leak has manifested over a period of time. Neither the figures relating to the number of deaths nor the nature of the medical disabilities and ailments have remained static. Considerable opinions exist on the continuing nature of ailments and impacts. The instance case deserves to be treated as an extraordinary instance of continuing wrong, and in which case the settlement judgment cannot be treated as a bar, nor the intervening period between the settlement and the curative petition can be treated as a matter of delay. The settlement has been arrived at in the course of interlocutory proceedings, though the question of liability, whether strict or absolute, has not been determined in the course of a trial. The settlement procedure virtually closed all the further proceedings. The gain on the one hand by way of expeditious settlement, and the loss on the other hand by reason of absence of concluded trial determination have to be seen as necessary factors. UCC, after having objected to the jurisdiction of the US courts, could not have taken a different stand before the Indian courts, and also canvassed the settlement has no bearing or relevance in the question of jurisdiction. It must be taken as a settlement in a manner of speaking, settles the question of jurisdiction against UCC. Consequently, it will be taken that implicit in the settlement is the acceptance of the liability for the MIC gas leak and the obligation to bear the damages through compensation. Since the settlement has to be seen only as a partial measure of compensation, affecting full measure of compensation will require UCC to continue to discharge its obligation even after the settlement judgment, regardless of any changes or alteration in respect of its status, either in connection with UCIL or any other entity happening after the review judgment. Non-discharge of the obligation to effect full measure of compensation has resulted in saving the expense. This saving measure will also be considered as a gain. These are debates in the subject of unjust enrichment and restitution deal with varied claims of restitution. In this context, the doctrine of tracing to reach at a value that has been saved has been invoked. Having regard to the arrangement that UCC have made post-settlement and avoided discharging full measure of settlement, its subject to doctrine of tracing can be invoked with an appropriate favor for the purpose of securing discharge a full measure of compensation by UCC and all or any of its connected entities.
What is it talking about? Paragraph 10.
Paragraph 10. Paragraph 10. Here the documents come in sufficient and materials and this.
Open page that is when we are applying on to it.
Okay.
Yes, yes.
Yes, please.
I just wanted to say one thing, because, and I must say, my instructions are to appear, I'm an American chap. Instructions are to appear in proceedings arising out of the suit. Now, I noticed in the paper just handed over, there are claims for relief and rehabilitation, including disposal of toxic waste, none of which are in the plaint. Because plaint arose out of the act suing on behalf of the people who were
We've
suffering.
taken note of it.
I am not, my presence here should not be taken as UCC acceding to the jurisdiction of Indian courts on any of the other issues.
The suit has come here. You said these proceedings arise out of the suit, Mr. Sarve.
No, there are matters here which are not in the suit.
Suppose now, to test this, suppose the suit was amended, then what will happen?
I'll tell you why. The suit was filed under the Bhopal Act as on behalf. The suit was filed under the Bhopal Act, expressly stating, so the plaintiff is very important, that this is the death and injury claim. Now, if that suit is being amended, and that was the suit which was filed in the US, which got transferred here, to which we acceded, UCC acceded to jurisdiction. If the remit of that suit is now saying, in 20 years after the accident, the government of India has spent material on removing toxic waste. That's not a suit for death and injury caused in 1984. If that amendment is allowed, would UCC agree to jurisdiction, not agree? They may not, they need not agree, but it may not have any implications here. The Indian court may say, sorry, I'm holding you liable. And then I don't keep any cards up my sleeve. Because if tomorrow a judgment is passed and it is put in enforcement, and UCC in the US court wants to resist enforcement, my presence here should not be taken that we have acceded to anything. Saying you participated there in the hearing, you took your chance in the Supreme Court, you lost, now you can't resist the decree.
You're looking far too ahead.
But I have been instructed by clients to make that clear because there are very far-reaching implications. So that's why I wanted to state it.
Okay.
I'm not stating it out of any arrogance or anything. The court must fairly know what our position.
Yes.
That's actually tried to address that question. So there are more than one point of view on this issue. And the more you get into the conflict of law ticket, there are so many routes which the highways and the bylanes which courts have looked at various principles to address this question. Maybe the course of argument, we need to look at some of them. I thought
See, one thing we were just discussing, when you do the calculations, say for in your earlier note of 2010, where you decided to
yes.
revise some expenditure payments.
Therefore, let me take a loss.
2010 is more than 25 years after the incident. Correct. What is the causation of a medical problem with this 25 years hence? Just as a
I understand. I asked.
It's also a problem.
I myself asked.
There can be many natural causations which may arise by lapse of so many years of time.
For instance, in the asbestos related cases, one of the cases was you have a series of employees where you get employed. Exposure to asbestos in the environment. The courts try to look at this question by saying, what's the degree of exposure to environment? What's the degree of exposure to a employment related situation? If there could be even a marginal degree of difference between an exposure in the workplace, then the court will lean in favor of compensation. Therefore, these are principles with the common law.
Whole problem is that this would be dependent on evidence.
No, I understand. That's why
That's the problem. If evidence was placed before a trial court, you may be able to show that, look, even 20 years hence, so and so has a causation for it. It may have a part causation for it. Or it may not have a causation.
Correct.
We are not dealing with any evidence. We have no evidence. We have the suit never went to trial.
That's a matter which, of course, will be a matter of some concern and anxiety for the court before it can proceed to say some final word on that. I've also thought about that. But since the Act virtually replaces, and your lordships giving a stamp of approval and the settlement, and said the parents' patria in the Union of India will represent the case of the victims, even though the question of oppositional opportunity was raised by Justice Mukherjee, the challenge issue. So these are dimensions virtually brought in a process of the welfare commissioner acting as a court, trying the nature of claims and the categorization of the claims. The Act therefore endorsed it. And the Act has been endorsed by this court. The process adopted as statutory framework for all practical purposes must be treated as a valid process. And we be close enough for the purpose of looking at not only the enforcement of the settlement, but also if the need arises for looking at the review of the settlement itself. Whether there is an agreement on that question or not, there'll be little more persuasion arguments will be required to do that. But I thought that's one way of looking at it. Of course, there's no trial. Nobody can ignore that. But the Act replaces every process of it. And the Act has become the field where everything will take place. So the Welfare Commissioner went ahead in looking at these claims. And the figures changed over a period of time. And they looked at those criteria which have been laid on under the scheme, not any arbitrary criteria. So under the scheme, uniformly for all people. They've also tried to address this question, what will be whether if there are multiple exposure, multiple reasons for a certain kind of ailment, the medical disabilities, which one I would choose as the most proximate reason. So they've also tried to examine all that. So there could be some areas where the figures may be disputed and so on and so forth. So after having a series of conferences with the Welfare Commissioner and the authorities, I also have some questions in my mind. How do we really address some of them? It is not as if it's a closed case where things can be written clean slate. I'm not saying that. But regardless of all that, because I think in a case like this, these dimension aspects are bound to be there. They're bound to be there. You just can't close your eyes to all that. Therefore, you post-2010 Welfare Commissioner has arrived at certain figures, which are vastly different from the figures assumed by the court. when the settlement judgment was delivered. Then whether these figures, which are a due process of law determinations, would not qualify as grounds and reason as set out in the curative petition for the court to look at.
How would the court assume any figures? The union must have given those figures.
Yes, sir, we have the curative petition.
No, not curative. At the time when the settlement was accepted.
No,
And then the
settlement,
figures must have been given by the union.
That's the only question. But in the settlement, the figures were A, but the real figure that emerged after a due process of law is B. Therefore, we're looking at whether there's due process of law.
84 to 89, you did not have the correct figure. And you entered into a settlement.
So in the entire assumption on the review settlement was in certain figures which were not on the basis of any final concluded examination. Therefore, a number of deaths from 3,000, ultimately more than 5,000 odd deaths. And as confirmed with the Welfare Commission. Even though there is an area where the interveners and the petitioners say the number of deaths is 22,000, and we stand by something lesser than that. So I'm still trying to find out whether there is a area where there is a conflict or disagreement.
When
I don't presently come to that.
welfare commissioner determined these figures,
Yes, yes.
whether company was heard. The company was heard when welfare commissioner determined these revised figures.
The Supreme Court endorsed the scheme under the Act.
Correct. And
So
under the
once the-
scheme he was acting.
Under the scheme, therefore, their presence was probably not required at all. And if that was required, they could have asked for it. I mean, no determination with the Welfare Commissioner Court to go behind our back. Because those
I was
demands,
saying they should have asked for it. The issue is if the welfare commissioner is acting under a scheme of the Supreme Court, then on one hand you want to open it, on the other hand you want to say that it's for them to ask. There's nothing for them to ask because in their perception, whatever their liability was, more or less, was reconciled to a figure which they paid.
Right.
If they had not paid it, of course, issues would have arisen.
these figures,
Therefore, when I read through the list also, what corporate shenanigans went through it in terms of how the company was, from one entity went to another entity, from another to
I'll completely clear. I am not on that for the time.
completely irrelevant.
I'm not on the time frame being. I'm not on that.
Because that's only fixation of liability. How to fix it, those principles come in if something is quantified against them.
Absolutely.
They don't pay, then whether by alleged subterfuge they can avoid the liability is where we go behind and see how the corporate restructuring has taken place.
But in 2006,
In my understanding.
why not just not ask a question? When did you first discover that the figures were? In October 2006, the Union of India files an affidavit in this one. And in that affidavit, they say that in any case, the validity of the settlement by no stretch of interpretation can be questioned in 2006. As each and every claimant has got compensation as per law and is entitlement. And the amount of settlement has finally been found to be in surplus or excess of the actual requirement. And the leftover amount in Reserve Bank is 1,500 crores, which was directed to be disbursed pro rata. This is in 2006. After the curative, on 2nd November 2011, the Welfare Commissioner files yet another affidavit saying all claimants have been paid compensation twice over and there is no.
So that's in terms of the original settlement corpus, not in terms of the increase in the number of deaths and the increase in the number of other categories of age.
Claimants are paid.
The present claimant. Let's be very clear about it. The review judgment talks about the present claimants.
Is it your case that when they say claimants have been paid, some of them and number of them have not been paid at all at that stage?
No, that's not the case. The question is, if the number of deaths assumed was 3,000, it is now 5,749 according to the Welfare Commission determination. And I said, if
All of
that
the-
number has gone up.
So all of them have been paid according to whatever formula.
So that's why.
Then why is money lying? Things are wholly contradictory. Is it that we don't think government will be pocketing money for its own benefit?
That's not the
Correct.
thing what the government.
So to the last penny, they would like to disburse the amount given by them, and in terms of as a welfare state, as envisaged in the latter judgment to which the
There are two
government
aspects.
court has given an imprimatur, they would have put in funds.
But honestly, the answer should be there is not one single claim pending for the Welfare Commission.
The question is not whether the claim is pending. The question is the quantum of compensation. The quantum of compensation was fixed at 1 to 3 lakhs. Nobody got beyond 1 to 5 lakhs. The government of India extra compensated something else. How do you reckon that in the account? Therefore, we are talking about it.
Mr. Attorney,
Liability, obligation.
No, let's be very clear. The claims have arisen because of the 2010 decision to enhance the compensation in case of death to 10 lakhs. Is that the reason or some other reason? Because then you also bifurcated the amounts as you're given in the table. Is that the reason? What is the reason? Because did the shortfall take place because the compensation was increased
Yeah.
from
There are
3
two.
lakhs?
One is a number.
Number we
Number.
understood. One
So
number.
the number.
Here the causation
And
was
the quantum per person, for instance, for death, we're liable to pay 1 to 3 lakhs. But the number increases, right? And the quantum also, we have a problem. With the quantum of compensation also, there is a question. If somebody was entitled to get, you look at the value of life in India. You're looking at 1 lakh to 1.5 lakhs. And the government out of here, in account of the desperation of the gas victims, after so many years said, look, we must go to the
after
rescue and
25
give an
years.
extra payment
No,
to
but it took you 25 years to realize that the compensation paid fixed earlier was wrong.
That's why these two reasons, one is the number. Number
I
is
just-
important factor.
Just as a matter
Number
of
is
fact,
very
I just went through
Yeah.
the income tax slabs for 2000. Wow,
Lots of read, yeah.
I just tell you, the income tax slab as far as 84-85 is concerned, the exemption was 15,000. Below that, above that, everything was taxable. If you crossed 1 lakh, it was taxable at the rate of 60% plus 12.5% surcharge. That was the maximum tax slab. 1 lakh was the maximum limit. Now in 2010, the exemption was 1,50,000. And after 5 lakhs, it was the maximum. Forget about that. That doesn't matter. That doesn't matter.
See, value of money will have to be
Yeah.
seen
We'll
from
also
perspective.
kindly look at why is the union so concerned about saying, I want to press the curative petition. We are talking about a loss of life and loss of several precious aspects of life to a large number of people.
How much money would the government have put in?
I play that. What we have a certain figure available. I play it on that. But in view of these questions,
Only one thing, as a matter of fact,
loss.
in 2010, you took a decision to pay 10 lakhs.
That's why we an ex gratia account.
Correct.
Ex gratia.
Was that amount paid by the government to each and every claimant was identified earlier?
That's right.
Everybody was paid 10 lakhs.
Yes, yes.
Still, man,
I will give you all the data. It was a very depressing situation.
So, I'm still not able to. I don't know.
Can I do one thing?
How can money still lie? Which
Can
was
I
deposited by
do
the-
one? Can I do one? I have a certain set of figures of the data available. That is given some information. Can I probably put them in a perspective? Right?
Amount is balance.
Whoever wanted to be paid.
there is not a single claim pending is
Wait,
the
sir.
affidavit. And the RBI on 29th June 22 gave a letter saying amount now available for disbursement 50 crores 25 lakhs. Slide in the bank. 22 June.
Because you had a liability in terms of welfare state emphasized by the court. Do I take it everybody has now been paid?
I take a loss.
Everybody has been paid in terms of 2010 decision, whether everybody has been paid.
Yes. What I
been
want
paid.
to play is how do we look at those figures? In what manner it was
You
done?
can't keep
And
looking
then-
at attorney at those
Correct.
figures. How to
I-
look
I
at
just-
those figures? How to look at 2010? How to look at 1984? How to look at this question? Let's not complicate the question.
No, I'm
which
not.
is there.
My question.
The question is very simple, and you have answered that everybody has been paid.
Right.
Now there's no liability pending. Then why is 50 crores lying?
Now
Who is the 50 crores meant for?
that will be explained in the note which I am placing.
Which is this
Now-
note now?
Now, you're not standing first.
Is it some other third note?
This is a note in support of these figures in the curative petition, in the curative petition, there are three claims. Claim 1, 2, and 3.
Yes.
Just kindly turn to the second page of this note. This gives the status of
All this will be some claims are not in the scope like environmental degradation. Where is the vendors will now very open source. Yes, so you can hide it. It's the way of responding if you know. This is very well like
Mr. Attorney, only one thing, you are given these figures. For example, death figures 3,000. This start second page of this note we handed over. Second page, right? Now, actual number of cases were 5295. Correct.
later.
So we want to know whether we have paid all these 5,9 in all these cases, 5295 cases at the rate of 10 lakhs. We have paid to everybody.
Yes, sir. I'll show those details in our compilation.
So therefore, whatever amount you have specified here, according to you, and everybody has been claimed. Additional claimants were identified later on. Everybody has been paid.
Yes.
Is that correct?
Yes.
And look at it, look at the irony. 84 or 85 people would have died. At that time, you gave 1 to 3 lakhs to the family members. After 25, 26 years, you enhance it to 10 lakhs. By the time one generation would have gone.
That's all the more a reason.
1 minute, please. That's the irony that you take 25, 26 years to decide what is the amount. And if you had to take that corrective action, you should have taken it. I could understand the curative was filed decided in 1991. The review was decided in 1991. Review. I'm correcting myself. 1990 or that by that time you knew the figures. No. Death cases, you knew the figures.
No. That's a problem. The welfare commissioner has to engage himself over a period of time to look at the number of deaths.
What can be done if for 25 years you can't come to the figures?
That's not a question of 25 years.
Sorry, it's a reflection on the government rather than anything.
With great respect, Lord. Great respect.
Of course.
The question of determining the number of deaths, is it merely a jugglery with figures? No, it has to go through a process. So the process went on. And within 19...
Process goes on. Annie, please turn to your current note. Turn to the table at the first table which is there. Correct? Turn to the first table.
These are figures.
Yes.
Which have been stated in the curative petition.
Additional amounts required due to increased fatalities and injuries not taken into account. Correct? Now let's go category wise. In case of additional amount required to be paid for death is 53 crores. Correct? The amount required for permanent disability is minus 208 crores. The amount required for temporary disability is plus 77 crores. The amount for severe cases is minus 78 crores. I'm skipping the next for the time being. Loss of property minus 74 crores. Loss of livestock minus 49. Where is the difference coming? And now I'll flag it. The difference is coming in minor injury cases, where instead of original amount, you have increased it by 1,000 crores for minor injuries. If you want to distribute funds for certain reasons,
Not on any ipsy-dixy, on the basis of the process of the
No, but then
the chart shows it.
Minor
No,
injuries.
these two pages.
Minor injuries are after 25 years, suddenly for minor injuries alone,
You have to pay
for
only
other
amount of
things you find your funds
20,000.
are actually in excess.
No.
But for minor injuries, suddenly you say, I need 1,000 crores more for minor injuries.
Not
This is what it means.
The question, let
What
me
is the definition of minor injury?
You would not just
What-
give me a little time.
What is the
to explain.
definition of minor
Let
injury?
me try to explain this. And these figures at pages 1 and 2
Yes.
are what is the figures derived upon by the settlement judgment. These are those figures in 1991. Now, after 1991, when the process of review of the consideration of those claims, which were came to be registered over a period of time, and the registration also came to a conclusion somewhere around 1996 or so, then the consideration took place around the 5-6 years. The review process came to an end of all this somewhere around 2005 or 2006. So by that time, we knew the exact number of deaths and the shifting of cases from
What I'm
minor
saying is
injuries
the
to
rarely
major
is-
injuries, permanent disability.
The rarely seriously affected, the loss of property, loss of livestock, are all where less has been spent than anticipated. But permanent disability is other. But suddenly for minor injury cases, you up the figure because you try to cover many more people. And
Great
how
respect.
after 20
With
years
great
minor
respect,
injuries have to
even
be
a
taken into account.
categorization. No, I wait.
Then I'm sorry, doesn't evoke confidence.
The question, why it all happened, how it all happened, there is enough explanations for that. There is nothing which has happened by any arbitrary criteria. The question of a minor injury becoming a permanent disability was, for instance, there are cases where I said death is owing to MIC. The commission said no, it could be for other reasons. Therefore, claimants have been rejected. Therefore, if a shifting of one claim from one category to other category has been under the due process of the scheme endorsed with the honorable court. It is not.
One more problem.
Yeah.
Assuming everything in your favor, that curative is maintainable,
Yes.
we can entertain it. But again, all this becomes matter of evidence and matter of proof.
I will try to address that.
And that is curative,
I
you have to
will
do it
try
as
to-
fact-finding exercise.
I will try to address that issue. Now, if your lordship.
You assume minor injury cases of 50,000. Now you are saying there's 5.25 lakh minor injury cases.
I'm sorry. Because we've been grappling with this for 10 years. The affidavit is filed by the union in 2011. The total figures are 574,376 in 2011, which is the same figure in the attorney's.
Yes.
It says all this has been done. Then it says we want to tell the Supreme Court that the government of group of ministers said pay 10 lakhs. So 10 lakhs for death, 5 lakhs for permanent disability, 2 lakhs for cancer, renal failure, etc. Then 10,000 under death for awarded as injury, etc., etc. It is pertinent to the figures mentioned in para 9 may be varied. Group of ministers is recommended. In addition, 582 crores has been released, and all this is paid and done and dusted. Is the affidavit in 2011 for same number of figures? Post-curative. Your lordship must see that.
Right.
Because that's an affidavit, it's a reply of 21st November filed by the Welfare Commission.
What I'm stating here is not in deviation from what we stated in the affidavit. Kindly turn to pages 4 and 4 onwards of this note. So what your lordship read in pages 1 and 2 was the position obtaining in 1991.
Was any claim laid towards relief and rehabilitation measures in the suit?
We don't just read these 2 pages, then some.
We'll read. I'm just saying, see, you are trying
Kindly turn to page 4. Page 4.
Please understand, you are trying to bring in claims here. You're never part of the suit which was resolved. If you want to do some other claims in respect of claims, then you can't do it in a curative petition.
May try to understand it like this.
in Charanlal Sahu,
I will
constitutional
read.
bench,
I
the
will
Attorney General made a statement. I'm sorry, Attorney General made a statement. We are not claiming anything towards this.
At that time, the attorney did not know 5,000 people have died.
No. I'm sorry.
The attorney did not.
The
Nobody
government
knew.
of
Nobody
India,
knew at that time.
the government of India would not seek any reimbursement on account of expenditure incurred so moto for relief and rehabilitation of the Bhopal gas system, nor will the government or its instrumentality make any claim on its own arising from the disaster. Now, if the government has spent monies on curative work, that is money spent by the government, independent of this, can they bring an action against UCC, the separate matter?
I definitely answer.
No, the query was different. There was a claim made for payment of compensation out of death, disability, etc. In the original,
Yes.
no discussion about it. We are on this claim number 2 and 3 is 1743 on account of
Your Lordship
relief and
reading
rehabilitation.
Your Lordship reading it.
Claim number 2 and 3.
Page 3.
Whether these claims were made in the suit. Claims under these heads were made in the suit. That's what we are asking.
Claim on account of environmental degradation. These are fresh claims which you are seeking to make.
Claim 1 was certainly made. But claim 2 and 3, whether they were claims made under these heading in the suit. Claims 2 and 3.
Claims 2 and 3.
How can they, my question is, how can they arrive in a curative? If you want to claim some other amounts against Carbide on account of your better knowledge 25 or 30 years or 50 years hence, file the proceedings. You can't do it in a curative petition. Who stops you from?
I was saying,
May I read Your Lordship's kind consideration. How did the review judgment look at it? And if the curative petition, if I am.
No, you may be right also. You can argue that. As a matter of fact, we want claims 2 and 3. Under these heads, there are claims in the original claim.
But there are some parts of the judgment where these issues were flagged, but not necessarily addressed.
It is not,
I saw that.
Mr. Attorney, I'm not able to comprehend at all this aspect. This is a compromise in a suit. Let's not say, oh, this is a very unusual thing that has happened. These episodes have occurred all over the world periodically. Unfortunate times. Now, magnitudes have been, yes, many of them are magnitudes equivalent. See, in India, fortunately, we've been fortunate it is not arisen. One is not denying the magnitude, but something you have not claimed. Therefore, your best claim can be, well, how can there be a settlement on this amount? Because nothing was claimed on this account. If it is not claimed, it is not settled. Chapter is over, claim it. Therefore, I put a question, you claim it. If you claim it and you are entitled to claim it, and if they want to defend it, and they'll defend it in whatever proceedings arise. In a curative, how can you go into it? That's the whole issue. Claims 2 and 3 never forming subject matter of the suit. If, in accordance with law, you are entitled to claim it, please. We are not prohibiting you from claiming it, but we can't go into a curative in this.
Just
The multiplication of figures, what you think should be now, I want this also, I want that also. Maybe you are right, but there's a process by which you have to claim it.
I tried to find out in the compilation. I could not locate the ends.
Claim 2 and 3. Let us say, if you remove claim 2 and 3, what can you claim against them? According to you, I am taking your case at the best.
So, Tony, just coming to your figures, I would probably the figure at the table A is 675.96, which includes this figure of 99, which
955.
955 may be wrong because it doesn't tally. I don't know how you've taken 955. Additional amount in crores you've taken. So 675.96 is one. If table number 1 or page number 2 of your table.
table number 1 is page 1.
Two.
Page 2.
Page 2.
I'm talking about this.
Of this third
Appendix
document, Appendix A.
Appendix A.
the Charan Lal's judgment came, one of the challenges was in what capacity the government suing. The Attorney General made a statement saying we are not going to be pressing for any claims of recovery of what the government has paid. That's in 89. This is 86.
Let me look at the judgment. Let me tell you why it all happened. Look at it.
Why is that the story?
Let us look at
Why, how,
Let us
who
look
is
at
wisdom,
kindly-
whose
kindly
lack
let
of
us look at
wisdom
the
is
context and how certain submissions are made. So we are looking at a very extraordinary situation. Sorry to repeat that, because in this extraordinary situation, what could have been anticipated? The only concern at the review, at the settlement order was if that trial were to go on for long years, unending.
Correct, correct.
That could be avoided, and to
So
obviate
people,
that.
therefore, the persons who have suffered should get benefit at an early date. That is the philosophy of a settlement. Correct. Those monies were given have to be disbursed. Now, you made certain statements because to benefit the people who suffered in this. Now you say no, government is spending much more money on different aspects. They are, as tort fees are required to be parceled with those liabilities.
Yeah.
Claim it, and it will be tried. How should in a security be parcel this on to them? Whether it is a claim of grief and rehabilitation, whether it's participation of environment degradation, all these you may not have a claim, we don't know. But you are wanting us to determine these claims in a curative petition dealing with the issue of claim satisfaction of the persons who had suffered various forms of injuries and ailments. How do you mix up all this? How do you do this?
Responsible needs to go through the review
government
and the initial settlement order. I'm not saying these questions are to be discussed like that. But how do we find an answer to this very vexing question? So at different points of time, the courts have looked at certain dimensions of the case. Certain dimensions of the case, and therefore you gave an answer. And stand was taken by the Government of India or with other parties. So on the basis of certain assumptions of facts. So therefore with the review.
Those assumptions,
Let me go through the review.
let us say you find no, those assumptions today don't hold, get them determined in proper proceedings. Please don't put this in a curative before us. Is all we are saying. If after 39 years you want to now sue them for something, please do it if you can. Please recover it if you can. Actually,
number one.
claims is like some fresh suit which you are seeking to file. Interest and LIBOR rates, CPI to be applied. You are filing a claim, you file a suit then. File a suit for whatever you think is recoverable against them. After 39 years.
Course.
Just
Filing a
just
suit.
one more thing. Just turn to your table once again. I don't know. Somebody has to apply, because here you say, as per the Supreme Court order, the total amount provided is
Reading at which page?
page 2. Sorry,
Page 2.
the next
Appendix A.
appendix A, column number 2. The total amount provided as per the Supreme Court order was 725 crores.
Yes.
725 crores. Then we turn to the page 3. The total amount paid ex gratia in terms of based upon the Government of India decision dated 24/6/2010, GOMM recommendation dated 27/9/2010 is 740.28. There, the gap is very little. It's not substantial, even if you go by your figures. And the figures get really, there's a change in figures largely on account of the fact of the minor injuries. Minor injuries figures going up from,
Astronomically.
it's virtually from 50,000 go to 5,27,000. And that makes a difference of 955, 1,000 crores virtually.
With these numbers,
So these are these figures. Then obviously there's something little odd. There is something difficult because the other numbers which have really is 1,000 crores with regard to the Government of India expenditure and 315.70 crores on account of environmental damage. Somebody must have done some calculation. These figures will have to be all. How do we estimate?
these are only abstract.
So dehorse,
I've given only the abstract.
endeavoring to put it on dehorse the settlement. You feel you are entitled to number of amounts more. It either did not specifically get claimed in the suit or otherwise. Please file whatever you want to before whatever court you want. How can you do it in a curative petition? That's the question.
We'll also kindly turn to some of the observations in the review judgment. And
Tell us where it says
And,
that everything can be opened whenever you want. It is so, we'll see.
Not asking, not what is the definition of minor injury that is defined in an affidavit of October 2006. That whoever was present and filed a claim because of the trauma that they had to suffer because of the gas leak. It's in their affidavit. I'm not exaggerating.
That was defined as a minor injury.
Yes.
these are of course under the scheme there are certain
And the government's words were, whoever was present and filed a claim was granted compensation on account of trauma that had to be gone through. And that the basis of mere presence.
What is the compensation amount, Precedent?
I'm sorry.
What is the compensation amount?
50,000.
It's that minor.
50,000.
20,000.
Ranges, there's a range.
Therefore, they say we have paid extra 600 crores. Now net present value applying live on.
These are the points.
That's the security.
See, from 50,000 cases of people who may have suffered a trauma, you are, for which 100 crores was provided on 20,000 rupees, you said actually people who have suffered a trauma are 5,27,894.
That's
And therefore we spent 1,000 crores more.
right.
there are
And we had checked for the population of Bhopal at that time was around that thing. 5 million.
56 wards.
So everybody
But
suffered
the
trauma,
purpose
everybody
is
they've given a figure.
There are defined set of wards where the gas leak exposure were determined, and all these people within the 56 wards with a minor injuries category was to be
So if
redone.
you are saying trauma, we are not disputing. So you say that anybody who has been in this affected ward will be effectively treated as somebody who suffered a trauma because the gas leaks occurred there. Therefore, you give it to everybody. Nothing wrong with that. Question is, on this basis, can you open a settlement?
The number is a very important.
Number is because you
Number very
knew what populations were there. You chose and thought that you will give it to something more. Now, if you want to give it to everybody who has a trauma, salutary benefit.
No, we didn't choose. It's all in terms of the court saying you will go to process this claim under the scheme. The scheme was a well-defined procedure, and it was not an open-ended issue. Therefore, if the scheme allowed people to lodge claims and the commissioners to do their job in terms of the criteria, then unless somebody has to say, yes, all this is wrong.
No, it's not necessary to say it's wrong. Somebody has to say also it is right.
I'll tell you why it is right.
Without evidence, how can it
I
be
shall
said it's right or wrong?
Therefore, we are only.
You may be right, but how can it be decided?
Therefore,
In a curative, you want us to decide it. We are again and again repeating the same thing. In a curative, what you are saying is, this is being paid by us, ask them to pay this to us. This is what, beyond that, we can't go in curative because we are only dealing with the settlement. There is no trial here, there is no trial there, there is no trial anywhere else.
I quite see that. If the absence of a trial, that's why I said if
Please
that
see.
trial was.
All the sympathy for all the people who have suffered. Cannot ask us to turn into such an ad hocism
Look at
on determination of amount because you say you are wiser today. That's what is happening.
Yeah. It is I look at it like it's not logical person say that. And before I do that, can I read both the settlement order and the review judgment, whatever effect they have, bearing on what we are trying to report. So, we'll also kindly pick up volume 1 of the respondent's documents. page 45, that's the first settlement order.
What do you want to read?
Agree. Please turn to page 41, which is the first order in February 14.
Just one clarification for, if you turn to your chart at page, sorry, I'm taking you back.
Page number.
If the figures interest.
Appendix A.
Appendix A. The amount which was initially provided was 725 crores. Is that correct? As per your chart itself? Then you have additional amount required to be paid. That's an extra amount, which is 675 crores. Is that correct? This is above. This will mean over and above 725 crores. Is that correct? Now, at page number 3, this figure of 740.28 crores under the heading 2, Roman 2, capital 2, ex gratia amount.
Yes.
This amount is the actual amount paid or is the additional amount paid?
Actual amount paid minus,
Not the additional amount paid or the actual amount paid?
minus the initial amount received plus this deducted, less amount. The amount was less.
So, attorney, do you mean that you have paid 675.96 plus 740.28? Have you paid both?
Yes, yes, yes.
Is that your case?
Correct.
No, you have paid, therefore you have paid 675
In excess.
with 675 was paid initially. And thereafter, after 2010, it became 740.28. Or it was in addition to it.
This is in addition to that.
$75.96 the additional amount you pay. They paid 725 and paid 675.
Both.
Correct?
And
Are we understanding correct that 725 crores is what was envisaged and provided for? This amount you would have paid, but still somehow 50 crores is lying, which we do not know why it is lying. Then you have paid, according to you, additional amount because of the increase between somewhere increase,
Because
somewhere
the
decrease.
actual number of cases, there is an increase. The actual number of cases. The number of cases assumed is 3,000. Actual number of cases 5295. Therefore, an additional amount required to be paid in the last
Without
call.
getting into detail is all arising for whatever it's worth account of minor injury. There are the figure, there are minor injuries otherwise. So you paid 725 crores you have in your hand to be paid. Correct?
Yes.
Apart from that, you
Yeah,
say.
one second. The number of cases assumed in the first column is 2,05,000.
Yes.
When the number of cases went up, which is there in the last but third
See,
column,
see-
5,74,000.
Because of this, you are required to pay 725 plus 675.
That's right.
Correct. This is what you say you are required
Correct,
to
correct.
And you have paid that amount.
That's right.
And you have paid that amount. Now, please be sure have you paid that amount, because otherwise the question will be posed to you, which we pose. Why is 50 crore lying with the RBI if you have paid? Who have you not paid? And if you now turn, see, confusion is, now when you come to claim 2, which prima facie is not, they use that amount spent on account of rehabilitation, etc. is so much.
And the amount ex gratia is 740.
Ex gratia is 740. So 1743 is what you have claimed under a claim 2. Then there's a claim 3, where you say environment degradation.
You must clearly say whether you have paid 725 plus 675 plus 740.
Out of the 725 which they were supposed to pay initially, they have total paid 740. This is what they want additional.
No. What they must say clearly, whether they have paid 725 plus 675 plus 740. Whether all three figures they have paid.
All the three figures, 740 is a part of the.
So our simple question is whether you have paid one figure of 725.
Plus 740.
No. Let us go by this. So 725 plus 675.96.
So they required to be paid.
There is addition.
If you look at the increase in the number.
But you
By
did not
reason
pay
of
this.
increase in the number,
Let's say increase the number. So 740.
Increase in the
Okay,
number.
let us begin first. You have paid
40.
You have paid 740.
740.
As there is 725 is here, we have paid
725 plus 740.
So that means that you have not paid any compensation to those persons who are identified subsequent to the compromise.
Not like that. 670 was required to be paid. Right. But that was on the assumption.
No,
the
but
average
there
amount-
you may not be right, because if you see the simple mathematics, if you see this 675 is in addition to 725. Just calculate it for yourself. Correct.
It because the difference in the number of,
So coming now to the straight question.
yes,
How much is the total amount you have paid on account of all these heads? Death, permanent liability, temporary liability, severe cases, minor injury, loss of property and livestock. How much is the total amount you have paid till today?
725 plus the ex gratia 740 which you made over.
Right.
This has been paid.
Right.
And ex gratia was also given to the ones with minor injuries?
Everyone.
The breakup which you gave, your chart is not complete there. In your chart.
And why is 50 crores lying with the RBI?
The interest amount over a period of time. And
No,
then I've
no,
told
no.
some
I'm not
425
able
people
to see.
did
You
not
have
have
paid
claimed.
this amount. This
I
is
will
out-
explain that. That's
This is outflow gone. So you should, all that should have been used in any
the
case.
question. One question is about the amount which has come into our kitty. How have we disbursed it? How the expenditure has taken place? So even if the amount 50 crores lying there, whether it is required to be paid over, in what manner? That's a different question. I am on a fundamentally different issue.
Mr. Tony, there's
If we have paid, suppose we not paid the gratia at all.
some difficulty. Some difficulty. If you just, Mr. Tony, during the lunchtime, just check up on these figures. There's some difficulty in these figures.
What do you want to explain on the figures?
Just to assist your lordship.
No, what is the figures? If you have some better definition of the figures.
I'll just come. Now, if your lordship look at this table, but what happened that initially when the settlement. Right, sir. I'm audible like.
Yes.
Yeah. Milord, initially the settlement came and then there was, Milord, hue and cry that how the settlement has been arrived at. So moto this honorable court took cognizance of the situation. And they said on the basis of assumption that this figure has been arrived at. Now the court was supposed to determine that what is that assumption. So these figures which have been given, if you lordship look at this table, 3,000 etc. which has been given is based on, my lord, the judgment which was given, which is on 4th of May 1989. I'll just read out, my lord.
Correct.
And what the court said that we have arrived at this figure on the basis of assumption. And if the basic assumption is ultimately disturbed in the sense we find.
No, Mr. Parekh, we are not on that.
No, Milord, I'm just.
We are on the quantum of the amount, not the figures.
No,
of
Milord,
the-
I'm just
under
explaining.
the
I
other
think
head.
my explanation will clarify.
Yeah.
So this, Milord, when we look at this number which is given here, assume this number is, Milord, based on what the judgment of this honorable court says. Now, the average amount which has been mentioned, this is the average amount. Again, the court said that in case of death, the average amount will be 2.33. So therefore, Milord, when they multiplied, the total amount came to 725. This is, Milord, for the number which is mentioned here, that is 3,000 sectors, that these are the total amount which has to be given. Now, what happened thereafter, Milord? This 725 was not disbursed immediately because it was subject to, Milord, the determination of claim by the tribunal. So the determination process was going on. So this 725, Milord, the interest accumulated, the interest became, so this amount.
Became larger.
Yes, Milord, it became larger. So suppose the amount was immediately disbursed, for example, in case of death, 233. Then, Milord, the entire amount of 725 could have been disbursed. Because, Milord, the interest became more. Therefore, the question is that interest amount who is entitled to, whether the same number of persons who are mentioned here are entitled to that interest. So this is, Milord, a separate thing like 50 crores. Now, 50 crores will go to the persons who were really identified by this honorable court on assumption that these are the figures. Now, what happened thereafter, Milord? The process of determination started. Now, the process of determination by the tribunal came out this particular figure, which is mentioned in column D, that is 5,295, etc. And then for somewhere, Milord, the figure has gone up, somewhere the figure has gone. Like in case of simple injury, it has become tremendous, and lordships are putting the question that how this figure became so much. Now, this is based on the determination which has been done by the tribunal on the basis of, Milord, documents which are produced.
So, what has happened, Mr. Parekh, is if you keep out this category of minor injuries, there is actually excess availability of about 275 crores. I've done the minus and plus only, basic mathematics.
The union had to file a review. It would have had to elect on whether it wants to continue with the settlement or whether it wants to discontinue the settlement, scrap the settlement, and say, we don't care about the settlement. Start the suit.
So why would in a review they be required to say so?
Well, it's binary. Either you stay with the settlement.
No, that's the same thing today.
No, exactly. So they don't file a review.
Even in a review, they would have said, look, we don't want to disturb the settlement, top it up, as they are saying in the curative.
They didn't.
They did. As a fact, they didn't.
No, what happened is something very interesting. Because your lordship does know the background. The review petitions I'm not saying it may be that it's a technicality that the union representing the review petitioners did not itself file a review, but it came and supported a review, etc. So you may say, in that sense, broadly, the Hura test is satisfied. I'm going on that basis. Taking up time on it. But then that creates.
Having heard the attorney for such a long period of time, we are not going to shut him out because the curative has not been
Exactly.
taken. So
I am wanting to point out something else. Your lordship tells.
Mr. Salve, one more thing, please. This was a settlement in this court. Now review is filed. Review is granted. Now under Order 43, the grant of review is appealable, specifically as an order of court. Now, if you're going to shut him out on curative aspect, then it will lead to a very.
I'm not saying that. I'm not saying that. That's why I said.
that's why
I'm not addressing a lot.
we already indicated we have flagged that issue, but on that,
No, that's why I
issue,
said I don't
would
even
not
want
like to shut out
I
the.
only said I'm not going there. What I want to show my lord is something.
To that extent, you are right.
What I do want to show my lord is what exactly happened. To inform the court. Please turn to volume 6, additional documents filed by us. This is the review petition prayers.
You mentioned the review petition prayers were to set aside the settlement.
Yes, I want to say.
But that's the by the other
The
people.
union said we support the review.
But the union never argued that the settlement be set aside at any stage.
I remember right in the opening, a subject matter dear to my Lord Justice Khanna and my heart came up, tax law. Because one of the first questions which came up was, having appropriated the money under a settlement, can you challenge the settlement? Then Attorney General, my guru, Mr. Sorabji said, we have not appropriated the money. We produced a copy of the finance bill. So there was a question of taxability of the interest on the purpose. So a provision was introduced in the finance bill appropriating this money and saying it goes to the exchequer. So there'll be no interest, there'll be no tax on the interest. So we said this constitutes appropriation. So this issue was very much at large. And what the union asked for is not set out fortunately for us. As Justice Venkatachala said, because nobody was hurt, we didn't keep it in the traditional confines of a review. Like your lordships have heard this case much beyond the confines of security. The lordships, in fact, said we will hear if the settlement has to be set aside. That is what was being heard. Because at page 1433, just to get the record straight, Lordship read that rather poignant comment by Justice Rangnath. It's very easy to say, go try the soup for those who have no stake. Those who know the realities of the uncertainty of litigation will never make that clear. Look at page 1433. Review the orders of settlement. Allow the appeal of the Union of India against the Madhya Pradesh High Court and confirm the order of the District Judge Bhopal. The Lordships have been on this. Direct the disposal of 350 crores as interim compensation to the victims. So, my lord, this would be on the basis that the judgment goes. So, we are back with the appeal. Allow the appeal of the Union of India against Madhya Pradesh because the High Court had appealed down the pro tem compensation from 400 to 250 crores. So, allow the appeal of the Union, confirm the order, direct 350 crores as interim compensation out of the sum deposited by UCC, retain the balance of the amount paid by UCC in the court as security to satisfy the final decree in the suit.
What was the total amount paid in court at that time?
Well, this was the total amount paid under the settlement, i.e. the 400 odd million. 470 million.
Probably before the district court it was 270 and the high court it was 140, and when it has come to this court then it was 470.
Yes. So, but that is how, and that money was paid pursuant to settlement. So the review petitioner
I was only saying what was the amount which is already in court, either in district or high court.
No, by the time this was filed, the entire amount under the settlement had been paid.
So that was so you brought in more money under the settlement.
Yes.
So that's what I'm saying. I'm saying originally what was lying in the court was
5 billion.
deposited.
I don't think subject to
So
correction.
pursuant to the interim direction,
There was a direction to pay.
I'm saying pursuant to the direction of the district court and the high court, was any amount deposited?
No,
or not
because that was carried in appeal.
so it was not deposited.
No.
That's a fact I want.
And the appeal came here.
That's fine.
Post settlement, the entire amount was brought in, and there's a certification. It's all noted.
So it's 5 million paid pursuant to the US Justice Kinnan's order. 5 million. That was the only advance amount paid. Rest was all paid later on.
Very small amount.
That's para 2A.
There's a very interesting thing I discovered in this. although people retire, even in the US, they have the right to call back judges. Judge Keenan kept hearing the Bhopal case in its repeated avatars. Even post-settlement, Malad 3 trials were held. They used to call him back. I think the last order he passed was at age 90 or something. He heard an action because they used to call him back to hear the Bhopal case.
The lighter side, your suggestion is all reviews here should be dealt with in the same manner.
But we have to seriously consider, even in the English courts, retired judges are so many times called back by the commercial court, come for a few days, sit, decide individual cases. Page 1433, Malad.
Yeah.
If your lordship sees the operative prayers. So what they said is of the settlement money which is coming, 350 you distribute, which is as per the internal order. Retain the balance as security to satisfy the final decree. Please mark the words. In the suit against street pending in the district court of Bhopal, and direct the speedy and expeditious disposal of the suit against the UCC by the district court and pass at the consequential orders. The union cannot file a counter affidavit, which is at volume 7, that makes important read.
In my pretty underline, like in my volume and yes.
This is volume 7.
Oh. What do you want to show us from this
Yes.
volume, Mr. Salve?
Please turn to page 1594. In the middle of the paragraph,
Yes.
the victim groups submitted.
Yes.
The victims group submitted certain material and studies to the government. Thereafter, the government took a fresh look at the matter, with particular reference to the long-term effects and potential hazards of the exposure of MIC and other toxic gas. And it was realized that an important element involved in the determination of liability and the assessment of compensation damages was overlooked, as stated here and after. While directing settlement, the court took into account the number of fatal cases at about 3,000 and the number of cases of grievous and serious personal injuries as verifiable from the records of the hospitals of cases treated at Bhopal was taken to be in the neighborhood of 30,000. Obviously, one of these figures didn't come from Union Carpet, they could only have come from the government. It is submitted for reasons stated that the figures are not accurate and do not furnish a sound basis for assessment of compensation damages to the people who have been exposed to MIC and toxic gases. It is further submitted that medical studies on the effect of MIC and toxic gases formed in the leakage have been conducted under the auspices of the ICMR, and further studies are being conducted, and a whole chart of other studies is made. Your Lordship turns to page 1596. Results already obtained clearly show evidence of psychiatric disorders such as anxiety, neurosis, and depression, pulmonary damage, visual disorders. With regard to pulmonary damage, etc., etc. Then we're on page 1597. There are some suggestion being made at that time. Cancer was not known. This was not known. 1597, fourth line. Besides, there is a likelihood of carcinogenic effects which may be manifested over the years. Research and investigation in this regard are continuing. In addition to the studies of long-range effects are in progress in order to evaluate genetic risk, organic brain damage, damage to the immune system. Follow-up studies are being conducted in children, etc., etc. Page 1598. Para 8. It is also necessary to point out that while the court proceeded on the basis that the number of dead was 3,000, the total number has gone up to 3677. The figure is based on records showing ex gratia payments to the next of kin. It is therefore submitted there is every possible of the number of dead increasing as the various results of the gas leak manifest themselves over a period of time. The environment damage, etc., is all mentioned, and the operative. Then, of course, they challenged successfully the quashing of the criminal case, and page 1608, para 23. The union says the settlement requires to be reviewed. It is with this backdrop, I just wanted to read a few paragraphs from the review document. Two or three things, Paul, I just wanted to clarify. Page 39, I'm sorry, page 601, printing, I'm reading slightly from some other one. Paragraph, page 600, 601. I believe it's page 39 of the paper book, security paper book, but my lord may have read it, the attorney read it from some other one.
So we had.
No, it is right. 39 is the right. 601.
The file, that file.
Which is the paragraph number?
Paragraph 5.
United States Court.
Yes. Something with Justice was read from Chief Justice Mishra's judgment. I just wanted to
Para 39.
Yes. Page 39, para 5. The United States Court of Appeal for the Second Circuit upheld the first condition in respect. So, in fact, the two conditions was Union Carbide shall consent to submit to the jurisdiction of the court and continue to waive defenses based on statute of limitations, and Union Carbide shall agree to satisfy any judgment rendered by against it in the Indian court, and if appealable, upheld by an appellate court in that country. Whether judgment and affirmance comport with minimum requirements of due process. Now, that condition, my lord, was appealed, and that condition was set aside. The U.S. Court of Appeals for the Second Circuit, by its decision of 14th January, upheld the first condition, and for the second one stated, if your lordship sees in the middle, it says of that passage 14, under the New York law, which governs actions brought in New York to enforce foreign judgments, foreign country judgment is final, conclusive, enforceable. Where rendered must be recognized and will be enforced as conclusive to the extent it grants or denies recovery of a sum of money, except that it is not deemed to be conclusive if the judgment was rendered under a system which does not provide for impartial tribunal and procedure compatible or procedures compatible with the requirements of due process of law. added, my lord, over the page. Any denial by the Indian courts of due process can be raised by UCC as a defense to the plaintiff's later attempt to enforce a resulting judgment against UCC in this country. Now, this is what the court was faced with. The explanation given, page 42, paragraph 10. One or two things, page 604 of the report. One or two things required to be explained. The attorney said he will show your lordship's jurisprudence that a settlement can be increased or enhanced. And he has filed 3 American cases. He didn't read them, so I'm not dealing beyond pointing out. This is brought against companies. So I about that. They have an interesting procedure in mass tort. This is the procedure under their. What happens is, unlike one of our systems, where your statement of claim, or particulars of claim, or as we call it, claim, must set out your material facts, your basis, your evidence, and your summary of evidence, and your reliefs, and your cause of action. In America, you only file a cause of action. So and so has committed fraud, cheating, deceit. I claim so much. That's all that you do. Then the discovery procedure starts. Then you ask for all the documents, and then you go on filing particulars of claim. So the mass tort lawyer, they have one at the bar, divided the plaintiff's bar and the defendant's bar. So the mass tort lawyers, it's always who comes first and files the first claim. Multiple mass tort claims come to be filed, and of those multiple claims, then it becomes a race as to who gets the lead of the case. Now, in that product, they have a procedure of a global settlement. So if there are 100 suits, you have a global settlement. All the suits of the mass tort get settled. Now, in that global settlement, you have a right to challenge. So different people whose suits are perforce getting settled, they can come and say this settlement is wrong, or these figures are wrong, or that figure. That's one of the two, including the one US Supreme Court case, which was cited, where a global settlement was challenged. And what are the principles? Now, we can't import all of that. None of that is relevant for us. In those mass tort settlements, sometimes you insert what are called reopener clauses. That if a set of circumstances come into being, it will be reopened. Today, we're not inviting our lordship to add a reopener clause to our settlement itself and setting aside the settlement. The settlement was challenged in the review on the ground that in mass tort cases, you must always have a reopener clause. This settlement did not have a reopener clause, therefore it's bad. And that was rejected. It's 43, page 605. Second line. The fact that the Union of India has taken over the right to sue on behalf of all the victims indicates that if there is a shortfall in the fund, perhaps it would be the liability of Union of India to meet the same. Some of the observations of the Vairis bench support this view. This is not the Charalal Chau case. The genuine claimants thus have no legitimate grievance to make as long as the compensation statutorily quantified is available to them, because the source from which the compensation comes into the fund is not of significance, relevance to the claimant. Nothing has been shown to your lordship in the parliamentary legislation to establish that this is such an egregious error of law that your lordship must revisit this. But Parliament made a law saying Union of India will consolidate and pursue the claims on behalf of all victims. It was for Parliament to say that of the money received, to the extent received will be paid, to the extent not received will be paid. The Union of India will make sure whatever is paid is recovered from Bhopal, etc., from UCCS. But there was nothing. And when the union argued, they said, we are taking full responsibility. Because what Mr. Garrett's argument was, you have taken away my right to sue UCC by the Bhopal Act. Nobody else, I can't sue. You've taken away my right to sue UCC. Tomorrow, if I'm not happy with the judgment, what happens? And the answer was, the government of India is accountable to you. That's how the law was upheld. That's what Justice Mishra is referring to. That the virus bench, that the virus judgment, which upheld the Bhopal Act, was on this basis. If your lordship now might move to the to para 16, consciously, the review bench says we are not saying whether we are not applying the MC matter principle.
46.
And they are saying so for a reason. If your lordship sees para 15 and 16, the last 3 lines of para 15 are very important. In fact, Bhagwati Chief Justice clearly indicates in the judgment that his view is a departure from the law applicable to Western countries. We are not concerned in the present case as to whether the ratio of MC beta should be applied to cases of the type referred to in India. We have to remain cognizant of the fact that the Indian assets of UCC through UCI are 100 crores. For any decree in excess of that amount, execution has to be taken in the US. And one has to remember the observation of the Court of Appeals that the defense of due process will be available to be raised. The decree to be obtained in the Bhopal suit would have to be a money decree. It would be subject to the law referred to in the judgment of the US Court of Appeals. If the compensation is determined on basis of strict liability, a foundation different from the accepted basis in the US, the decree would be open to attack and may not be executable. Nothing has been shown to your lordship that this is an egregious error of law or the review bench made some horrible mistake in coming to this conclusion. Today, your lordship is told, please apply NCMAP. But the review bench heard that argument and said, no, sorry, we are not going to do this because we don't want to put in peril the ultimate recoverability. Then, my lord, please turn to Justice Venkataraya's judgment. It starts page 48. Page 48, para 25. It begins here. And the point which the attorney made at page 50, para 30, the last line, in fact, against his point in the curative, the hazards of exposure to this lethal poison are as yet an unknown quantum. So the court is perfectly aware that we don't know where this is going to end. It's not that now you realize that you don't know where this is going to end. You knew then that you don't know where this is going to end. Page 51, para 33, last 4 lines. One of the points urged is that the likely long-term effects of the exposure have not been taken into account in approving the settlement, and the only way the victim's interest could have been protected against future aggravation of their gas-related health hazards was by the incorporation of an appropriate reopening clause. So this was argued. I can understand, in my humble submission, I perfectly understand this argument if you are challenging me, saying, look, a settlement without a reopener clause should be set aside. Then, my lord, please turn to page 55. And my lord, this should be the last word as far as this is concerned. Where at paragraph 45, your lordship say, on February 89, this court recorded an overall settlement of the claims in the suit for 470 million. I'm reading page 55, printed page 617. The first two lines of paragraph 45. So this one closes the debate. Old Alture principle must apply now. What is said in a judgment is the last one. If your lordship say this is the settlement, this is the settlement. Look at paragraph 46, first three lines. On 15th February, the terms of settlement signed by the Attorney General for the Union of India and the Council for UCC was filed and the whole memorandum was set up. Then came the consequential orders. Paragraph 48 at page 619. The first sentence is important. The settlement is the same in this review petition and writ petitions on various. So the settlement was squarely challenged. Page 621, paragraph 54. At the outset, it requires to be noticed that the Union of India, which is the party to the settlement, has not bestirred itself to assail the settlement or any motion of its own. However, the Union of India, while not assailing the factum of the settlement, has sought to support the petitioner's challenge, please mark the word if you don't mind, to the validity of the settlement. The Union squarely challenged the settlement. The Learned Attorney General submitted that the factor of a compromise or settlement recorded is not disputed by the Union of India. So that there is a settlement, Union of India doesn't dispute. The Learned Attorney General also made it clear that the Union of India does not dispute the authority of the then Attorney General, an advocate on record for the Union of India, in the case to enter into a settlement. I dare say, I don't think Ms. Subhashini used to work for the central agency, thought her name would be remembered in posterity in this way. She settled. But he submitted that this should not preclude the Union of India from pointing out circumstances which, if accepted, would detract from the legal validity of the settlement. All the contentions are noticed, but I won't take up your lordship's time reading them. In fact, just to give your lordships the para numbers, in para 64, 65, your lordship said we could, if it was correct, have even quashed the criminal case. We have the power. But on facts, your lordship said we should. So the power of the court is upheld. Number one important factor in the chronology of events as they evolved in those days. The settlement was arrived at when the challenge to the validity of the act is still pending. So the settlement became a point of argument in the act challenge, in the virus case. And one of the points was raised by Mr. Shanti Bhushan, saying Order 23 Rule 3B principle should have been followed before entering into the settlement. Your Lordship said that we did not set aside that settlement. And it was in that context now a full discussion is done. Please notice at page 632 printed, page 70, para 77, but that order of 15 February has been read, reread, and beaten to death. Please just see, ma'am. The order of 15 February refers to written memorandum filed by both learned counsel. Then starts the discussion from paragraph 106. One of the arguments was that this amount was composite for civil and criminal, and therefore it was for stifling prosecution, and therefore opposed to public policy. Your Lordships reject that. Your Lordships allow the union to argue that point at para 108. But this point ends starting from para 115 and ending at para 122 at page 650. On a consideration of the matter, we hold that the doctrine of stifling prosecution is not attracted in the present case. About the unfairness hearing, yeah, sense of proportion. Now, two important things, please see page 120, page 652, para 127. Give your Lordship a sense of what is the lay of the land at that time. We may at this stage have a brief look at the work of the medical evaluation and categorization of the health status of the affected persons carried out by the Directorate of Claims. It would appear that on 31st October 1990, please mark my lord, 639,793 claims have been filed. So that my lord, finally that 500,000 claims came to be accepted. Even in as early as October 90, there were already 600,000 claims. Because they are in curative. If in review this was not considered good enough ground to knock the settlement sideways, this can't be a curative, can't be a second bite of the cherry. And it goes on to say, it was stated that a considerably large number of claimants who were asked to appear did not turn up. Medical folders, total number of deaths had written so and so. Medical evaluation has shown so and so. Then a whole figure is given. Para 129 speaks of the latency period of toxic injuries that was in the mind of the court. And what is important is the discussion from page 655 from para 130. I don't propose for I to finish quickly. I don't propose to read all these paras. There is a full discussion about whether you can have multiple actions sequentially,
Split trials or participation.
split trials. And this whole the whole discussion goes on. And at para 134, this point is put to rest. But the petitioners say that in the process of evolving what is fair, reasonable, adequate, some of the elements of essential relevant to fairness and adequacy, such as provision of future medical surveillance and the likely future but unforeseen manifestation of toxic injury, having regard to the nature of the hazard, have not been kept in mind, and therefore please mark these words. The approval accorded to the settlement is on an incomplete criteria. But the UCC would say that the Union of India was aware of the possibility of such future manifestations of the effect and must be deemed to have kept those in mind at the time of settlement. But the point to emphasize is those who are not parties to the process of settlement are assailing the settlement on these grounds. In personal injury actions, the possibility of further aggravation of the condition and consequent aggravation are taken into account in the assessment of damages. The estimate of damages is a very delicate exercise requiring evaluation of many criteria, some of which may border on imponderable. And then, Malad, the whole discussion goes on this. And it ends by saying, even if the award is a once for all determination, these aspects will be taken into account. And then, after discussing the fairness hearing principle, page 97, in our opinion, showing that because American jurisprudence has been.
What is the paragraph number?
I'm so sorry, para 140. The American principles, your lordships have said, will not apply. Para 140. In our opinion, the right of victims relating to Section 4 of the Act to express their views on proposed settlement does not contribute to a position analogous to that in the United States, in which fairness hearings are imperative, either on their global settlement. Section 4 of the Act, to which right is traceable, merely enjoins the Government of India to have due regard to the views expressed. The power of union under the Act to enter into a compromise is not necessarily confined to a situation where the suit came to be instituted on behalf of the victims. Statute enables Union of India to enter into a compromise even without a suit. The right of being heard and read into form and subject to its constitutionality has been upheld in Sahu, subjects the Union to a corresponding obligation. But the obligation doesn't envisage a procedure like the fairness hearing as in the condition precedent to a compromise that the Union of India may reach in a situation in which it may do not necessarily to a suit. Accordingly, contention G is answered. The whole settlement is not vitiated for the reason alone for want of a fairness hearing. Likewise, the settlement is not vitiated by reason of the absence of a reopener clause built into it. Now, your lordships have not been shown any statute which was overlooked by coming to this conclusion, or some binding judgment of this court to the contrary, which was missed. In saying in a curative, this is a big egregious error. Please correct.
No, whether contention of the Union of India that award this consent order should be set aside, settlement should be set aside. Is it recorded anywhere at the time of hearing in this judgment?
Yes, the Union of India challenged this.
No, whether Union of India argued before the review court that the settlement should be set aside.
Yes, they did. In fact, they went to the extent of saying this is for stifling prosecution opposed to public policy. Set aside the whole settlement. In fact, para 142, immediately answers what Madam Justice Oka is putting to me now. Para 143, please see. The stand of the Union of India and other petitioners is that even upon setting aside of the settlement, funds should not be allowed to be repaid.
Right.
So they clearly challenge. Now the question was, what happens to the money? Your lordships in 142.
You read out.
Para 12. In here, Chief Justice Mishra's
Yes.
judgment.
Union of India, paragraph 9, sorry. Paragraph
9.
Correct.
Supported the stand.
Correct? Who have asked for a review. And in fact, one of the subject there to Mr. Gupta, he wanted me to read a paragraph. There, the union was criticized. The union was criticized for running the stifling of prosecution point, where your lordship said, behold, that the doctrine of stifling prosecution is not attracted in reaching the conclusion. You don't put out a consultation that Union of India would, under threat of prosecution, coerce UCC to pay 470 and apart. In the context of the Union of India, the plea lacks as much reality as any sense of proportion. In fact, the argument was interesting. It is bad because under threat of prosecution, UCC agreed to pay. Lordship said this argument is not only bad, it lacks sense of proportion because. PC page 98, para H.
Para H.
Yes. This also, my lord, answers your lordship's point. If your lordship sees para 3, keep the money back till such time as the decree is passed in the suit. What they were saying is, restitution, yes, we will keep it in trust to appropriate against any decree which may be made.
Suit should go back then.
Suit had to be tried. Page 661, para 146.
146.
Then one of the arguments was, may I read from 145. The learned Attorney General also sought to point out that UCC had subsequent to the settlement effected certain corporate and administrative changes, and without a full disclosure by the UCC of these changes and their effect on the interests of the claimants, the fund should not be permitted to be taken out of the court jurisdiction. However, Government of India also should not be free to appropriate or use the funds. We are not impressed by any of these contentions. It is not shown that the UCC brought in monies with any undue haste with a view to confronting Union of India with the fait accompli. The records indicate a different complexion of the matter. The payment appears to have been expedited at the instance of the Union of India itself. Strictly speaking, no restitution in the sense of any funds obtained and appropriated by the Union required to be paid by the back arises. The funds brought in by UCC are deposited in the RBI.
Ultimately, court says that restitution will follow, but that safeguard should be maintained.
Correct. Well, that will be, but they said in any case,
Right.
it will be done.
Court says.
Because, my lord, one very important thing your lordship say in 148, and this is the strength of our system. However serious the incident may have been, the rule of law, my lord, has to stand.
Yeah.
And in the middle of para 148, your lordship says it is the duty of the court to ensure no litigant goes back with the feeling that he was prejudiced by an act which he did on the faith of the court. That's a very important consideration. Then para 153, your lordship says we are satisfied.
Just one minute, just one second.
Now it's more. And what has become more is 50,000 has become 500,000 of minor injury. That's the long and short of the curative.
Yeah.
Manan, I submit that fact. There's no top-up issue. That's, I don't think I can assist your lordship anymore on this. There are a series of, I'm only staying it in 2 minutes. Series of affidavits filed. Series of affidavits starting with 1994, 1995, and ending as late as 2011, where the Union of India has opposed every single attempt to suggest that the settlement is inane. Affidavit upon affidavit upon affidavit. Argument before your lordship says the settlement has become adequate because the rupee depreciated. Go back to 89 and compare. But that can't be a ground for top-up. In the long and short of my submission.
So Salve, which are the pages of the affidavits where prior to curative,
Yes.
they keep saying that.
That's very important. May I very quickly show 4 or 5 pages and then I'm done.
Just give me the page numbers. That's all.
First is volume 9, 12 December 95.
That is your volume 9.
Yes, ma'am.
December.
95. There's a,
What page is this?
yes, it starts from at page 2149.
Okay.
Please just,
That's fine. Next.
yes, please just mark para 5 and 6.
Yeah.
Then, my lord, 2003, there is a 32 petition file in which your lordship direct disbursal, where this 1300 crore figure came in, the 1500 figure came in. That's only one out for the record. Your lordship's order is at page 2067 of volume 8.
Mr. Salve,
Yes.
can you do me this favor ask the instructing counsel on
a piece of paper.
On a piece of paper, just give the.
There is a written submission which I am filing and which I am inviting your lordship not to waste your time reading, except maybe
Does it
to assist you on these pages.
Does it have the paragraph number?
Yeah, it does. Beyond that, my lord, please don't waste your time reading it. It says nothing more. It says in 20 pages what I've said. 10 minutes to your lordship. And I don't think the matter requires.
I just need those instead of noting down, so there is no easier to locate those. That's all.
Are you doing it? TDCC, we don't want to do. Copies, please hand over. Your lordship had asked us to file written notes. So this is that written note. What your lordship is looking for. Yes, it's a Roman 5, page 7 onwards. Extracts are given in page number. Yeah.
Thank you.
But unless there's anything else, I can.
Thank you.
Since your lordships are going to discharge the alternative board, I take leave.
Thank you.
And we ask to go pro vote once.
Anything you want to say, Penny?
Not just to. Sorry.
Yes, anything else, Attorney? I think both of you already debated it. What can be an agenda in this?
I think we will even do it even earlier if possible.
No, you want to say something? I thought there's nothing
I-
to say one
I
way or
really-
the other. We have
a
understood
couple
the
of
point.
things
The
just to say.
point is in a limited compass. Yes.
It won't be any manner of repetition. Right?
Okay.
To tie up certain threads.
May I be excused?
Either threads are open or closed. If they are still open, how will you tie it up?
No. We have traveled quite a distance in understanding a lot of things had to be unraveled to comprehend. There are so many things that have happened over a period of time. And I looked at, again, there are three claims in the curative petition. One on the compensation amount to be upgraded. The other in relation to the environment mitigation, and the third in relation to the expenditures and rehabilitation and all that. So when the curative petition was filed, the Madhya Pradesh High Court was still in season of a writ petition filed challenging the issue of environmental mitigation. And the respondent then entered appearance, some objections were taken, and I'm told they had placed before the High Court certain documents in confidence, which I had no idea at all. And after the review, the curative petition was filed, the Union of India had filed a transfer petition, which is also tagged along with the curative petition and is heard along with that. But since the High Court is in season of the matter, the question whether they would be subject to a liability on that question or not is still a matter at large. And I don't think in these proceedings I could probably ask your lordships to go into that question because a number of other issues that arise, I don't think
That may not be appropriate.
fairly stated and on a high level of integrity of the procedure. We are confined to the question of the liability as far as the quantum of compensation for the victims are concerned.
This transfer
So muddle up,
the TP is also listed before us.
Yes,
It is listed.
there's a transfer petition which is
501.1.
That is filed by you.
Union of India had filed a transfer petition and the transfer even was not even ordered. Unfortunately, it was lying pending with the court.
So simplest thing is to pass a
So
dismissal
what
order
it
and
says
transfer.
in the High Court is in season of the matter, and the
Correct.
High Court will
Transfer
continue to
petition.
hear the proceedings.
Dismiss the constitution. That's all. Don't say anything more.
And say the High Court will give the petition number.
No, once we dismiss the transfer petition, that means we are not transferring it before us. That's all.
And I know, but anything Lord's mistake regards the continued liability of the UCC and this may or may not come in the way of the High Court.
You've not.
On the question of any liability on any other account, because I know there are some passages in the judgment which
We are not touching that.
obliquely looks at it, but I don't think
We are not
directly has a
touching that.
bearing on it. And the other issue also I think should be connected. I don't think I can also go in the question of the rehabilitation exercise compensation paid on that.
Cannot.
Because that's a matter on there could be more than one point of view, some factual, today we not even spend that money. How much more we'll spend all that? I don't think. So though they are part of the claims for some very policy reasons, they've been brought as part of the curative petition, but maybe for good reasons, I would confine myself only to this. Now I look at the turn of events over a
So
period of
claim
time.
3 you are not pressing.
Yeah, they can be pursued in accordance with law in appropriate procedure.
Appropriate procedure. Claim 3 goes there.
That's right. The review judgment broadly looked at 2 or 3 troubling issues. While it is true that Union of India did not itself file a review petition, but supported the review proceedings, and in the penalty paid paragraph of the affidavit, it says that the settlement may be deserved to be reopened. So the extent of reopening, the nature of the degree of opening, whether it is to completely undo the settlement or to have review limited to the extent of looking at the quantum of compensation, where probably that was the main focus, it seems to be, as I read the affidavit in total.
In the
Not that-
background,
that
in the background of the order in the review petition, you are wiser in the curative petition to the extent you would like to claim.
Maybe wiser,
Or
a
I'd
little
say-
more wiser.
So
No, I look at the, I
you
look
were-
at,
Therefore, you were fair to say that, look, in view of the proceedings gone by, it's not even advisable to pray for reopening the settlement. What you are, therefore, every time I said you want the settlement to be talked of.
exactly.
Yes, it has happened. There are certain other
Exactly,
facts,
exactly.
supervening circumstances
Exactly.
and facts which would require the court, according to you, to exercise whatever inherent power, whatever power you feel, look at a larger conspectus of the situation.
Great.
And in that process, you feel something more should be added to
That's-
it, given the figures and facts and figures which you
That's. Well, I look at the affidavit only from that perspective, and I think that must have been the whole idea behind it. I don't think Union of India, having gone into the settlement and supported it, said right for the immediacy and all that, but I said undo the settlement fundamentally. I don't think that was probably the intention. So the review judgment had looked at some of the basic concerns are urgent for the claimants and the writ petitioner. One is that having been kept away in the entire process of adjudication and Government of India had taken over the right to represent us. So there are several casualties, the fairness hearing and the participation in the settlement procedure and so on and so forth. And the quantum of settlement, the figures, how do you arrive at these figures? There could be no finality at this point of time. All those very important concerns were raised before the court. And they're all summed up in paragraph 55 in several contentions. Paragraph 55 of the review judgment. And there is observations made in the context of one, probably has been read in the context of some other contention. Therefore, I thought important for a purpose that the contentions raised in respect of each one of those must be kept within the scope of those contentions. And sometimes you read one in the context of another. That could be a small.
A to H. A to H.
That's right. Now, therefore, the paragraph 55, contention F is about, this is paragraph 55 of the review judgment. So I read from volume 1 of the respondent's compilation. The other contention relating to criminal prosecution, court settlement, I'm not looking into all of them. Contention F is the memorandum of settlement. The order that the court thereon properly construed make inference inescapable of the part of the consideration whether stifling of the criminal prosecution is opposed to public policy. This vitiates the agreement on the settlement is based on unlawfulness. That one contention relating to criminal prosecution. Then turn over to contention H.
That is regarding restitution.
Contention H, yes.
Restitution.
Even if the settlement is reviewed and set aside, there is no compulsion or obligation to refund and restore to the UCC the fund brought by it as such restitution is discretionary. Excise and discretion, the interest of the victims is kept in mind and restitution denied. But all even if restitution is to be allowed, the UCC would not be required to act upon and effectuate its undertaking dated so and so on the basis of it order dated so and so, vacating the injunction against us made. Then contention J. That the settlement required to be set aside in the original suit directed to be proceeded with on the merits. If so, and what other reliefs required to be granted, what are the directions required to be issued. So when you read contention J, let me read the first contention H at paragraph 142. 188. At the same time, it's necessary to remind ourselves that in bestowing a second thought whether a settlement is just fair and adequate, we should not proceed in the premise so has been finally established, yet to be decided in the matter goes to trial. For all those things went into the decision-making process of the court, looking at whether I should undo the settlement at all. So when the court has ultimately thought we're not going to undo the settlement, but we'll still, that's why when it gave a final thought on the question in paragraph 205 about what happened to the future symptomatic now, asymptomatic now, symptomatic later. So that's where those people may come for a claim later, we should take care of them. It ends at that. It ends at that. I would probably look at us, the lordships, to read this review judgment and the first order of May 4, 1989 together. Please read them together. Even if there was no reopener clause in the settlement, but the court in the 4th May 1989 order, the final paragraph, for all practical purposes, is the reopener clause. It is a reopener clause that the court has introduced into the settlement because the wide range of complexities which a matter of this nature was brought to the fore of the court. If I am not too off the mark in requesting the court to read it as the reopener clause, kindly come back to that. It's been read again and again, but so paragraph 38 of the settlement justification. So having said this, I thought, the way one can read it fairly, the review judgment thought there is already a certain guarantee and that can probably take care of. That's why although the arguments about settlement did not have all these concerns, those fairness opportunities are not there. So that, I think, in all fairness, to whatever extent justice may be done, paragraph 38 may be read as the reopener clause, and we read these judgments, we read as one continuum of a judicial process. They may have happened at different points of time, but one.
No, but in fact, settlement was specifically challenged on the ground that there was no reopener clause, and that
in the settlement.
Correct. And that contention has been specifically rejected.
Right. That's right. In the settlement, there was no reopener. But while the court endorsing the settlement had this in mind. So what was lost in the settlement was compensated and adequately taken care of with this paragraph. In all humility, and I don't think I'm doing injustice to reading judgments this way. If the judgment meant something, that's why I said this probably would not go in vain. So if that would not be too wrong to read it as part of to judgment to be read as a continuum, and this as a reopener clause, to whatever extent Union of India got to your lordship's notice, the unfolding events over a period of time, and I also read out that the ex gratia payment will be excluded under the scheme of the Act and all that. That's why I thought it is in a matter like this, while the undoing of a settlement has been put to rest by a curative petition and having regard to the intent of the Union of India in the affidavit filed in the review proceeding, the curative petition must be taken to a certain level where if the ends of justice of those who are waiting for justice for long can somehow be secured. And that's where probably the curative petition will be looked at. And I've seen all those proceedings in US. I placed on record about the complete lot of settlements. And those, I just give an index of those documents, where the US procedures on fairness hearings, and there are doubts raised whether for future claims, how do you look at them? So a bankruptcy process is also sought to be introduced in all those settlement issues. So it has flown in different directions. But ultimately, it's kept open. All these long proceedings in US, as business particularly, it kept open the possibility for people to secure probably the ends of justice at some point of time. So you put it at a higher level of principles of natural justice. And like all that you say is, I'm sure I must have had my day in the court Your Lordship, that's how it's put. So ultimate questions come to the mind of a claimant is, did I have a day in the court at all? I have so many years of waiting. So yesterday I did not point to Your Lordship about those fraud and mistake. Just a couple of paragraphs of
The paragraphs of what written?
I'm not looking at those documents about suppression of facts as a fraud from the point of view.
What are you proposing to read?
Your Lordship, listen.
What are you proposing to read? I want.
No, I'm just giving. We have placed on compilation of articles and extracts from books.
Yeah.
It is that yesterday, while Your Lordship raising, the concept of a fraud mistake is so wide. It's so wide. That's all I wanted to point out. If it is so wide,
Not the time period, then say arguments concluded or resolved.
Point, my lord, I wanted to.
No second, third, fourth.
It's only, what I'm trying to say is only, my lord, it's a very.
Please understand, some discipline of the court
I
proceedings
know, my
must
lord,
be
as I-
maintained.
as I-
We have heard both of you
No, I'm
against
not-
reasonable time. Now in a rejoinder, we will not.
Not rejoinder, but I'm just trying to inform them. No, not rejoinder. What I'm trying to say is, there is a figure which has been given. Now, in addition to that, once the medical, documents are made available, it will increase, plus not the future. So therefore, that will be an anomaly of the problem. That's all I wanted.
Thank you.
I'm grateful to that.
Keep your black.
Thank you.
Thank you.